It shall is related to the dispute of issues. They get to the status, legal status of them. The LCL has come, and the matter is pending since 2008. Matter all my pension benefits. Given detailed matter, my lord. Very urgent matter.
Urgent matter you have been awaiting. Anyway, have you served? Serve.
No, I have to serve.
Serve and come. Serve and come.
Okay.
Serve and come, it will be included.
May I permit to mention, Lordship, 3 revisional application. Initially, it was Lordship heard by Justice Biswajit Basu, but it was released for some personal reason. Thereafter, it was assigned before Justice Bhutia. Now, Lordship, after substitution, Lordship, the matter is required to be heard, Lordship. 3 preemption application, no issues, Lordship, regarding that is pending before the larger bench.
You serve and come.
Mr. Tanmoy Mukherjee appearing for the other side, Lordship, we have already informed, Lordship.
Serve him. Serve upon Mr. Mukherjee.
Notice,
No, you serve, it will be included. Serve and come. I will take it, no issue. Serve him.
But may be permitted to mention one matter. Yesterday, your Lordship was pleased to fix this matter on 8th August, but it was not reflected in the order sheet. Right?
In the order sheet. Why?
That matter, my lord.
Saurabh Babu.
That the special messenger was to.
Yes.
Yes, my lord. That matter, my lord.
এটা কি করবেন ওকে বলতে না ওকে সার্ভার ব্লক করে বলুন এখানে 8 তারিখ করে দিতে আমিও খেয়াল করে নি আমি সই করে দিয়েছি বলছি এটা কি টু বি মেনশন করতে হবে না ওখানে ও এ করে দেবে কোনটা সুবিধা হবে ঠিক আছে যদিও করে দিতে পারেন উনি ওটাই ভালো আর না করতে পারলে টু বি মেনশন করে দেখা যাবে ইট উইল বি অন 8 ইয়েস বেশ তাহলে পরের ম্যাটার গুলো ডাকুন ডেকে দিন একবার ডেকে দিন তারপর ধরে আমি
For the petitioner, item number 12, your lordship. Lordship, Mr. Karmakar is in another court, your lordship. Kindly give short pass over him. Much obliged.
I prefer short password.
Lordship, item 28, I appear for the appellants. By your Lordship's previous order, I have served upon the respondents about today's date. So Lordship allows I can come back once the list is called out.
দেখি কি হচ্ছে 28 the appeal is otherwise ready
Lordship, my clerk is on his way with the affidavit of service. He's just come.
Okay, I will take it up on 7. They never. Then এটা অ্যাসাইন ম্যাটার কেন দেখাচ্ছে? আচ্ছা, কে আছে? সৌরভ বাবু? আপনি কি আমি ডিকটেশন দেওয়ার পরে আবার লিখে নিজে কিছু লেখেন? তাহলে ওরকম হচ্ছে না, ইনকমপ্লিট সেন্টেন্স। None is appearing on behalf of the petitioner since the matter বাবা এ তো আসেনি। বেকার অ্যাপিল। কি বলবো ইয়ার? রাজা ঘোষকে চেনেন? রাজা ঘোষ, কমলেন্দু ঘোষ। চেনেন? হম, হ্যাঁ পুরোনো 2002 এর অ্যাপেল করে দিন। কি বলে না, এটা এটা অ্যাপিল। হ্যাঁ হ্যাঁ, পিটিশন অ্যাপেল ল্যান্ড is appearing after almost 21 years. I'm not inclined to dispose of this. I'm inclined to adjourn the matter. So moto. Let the matter be listed on আজকে কত তারিখ? 20, 31st of July. পরেরটা দিন, এই তো সবকটাই মনে হচ্ছে একই হবে। এটা অ্যাসাইন্ড হয়েছে এই 10টা ম্যাটার না? হুম। দেখ, সেম অর্ডার। হুম, দেখি ওটা একটুখানি স্টেট আছে তো একদিকে, একটু রেকর্ডটা দেন। সেইটা 3 না, 3 তো হয়ে গেল। 4 5 integration। পরে সৌরভ, পরে ডিপার্টমেন্টকে একটু বলতে হবে একটু। ও একই অর্ডার করুন, একই অর্ডার করে দেন। এই তো এই 31st জুলাই। এটা কি বারে একটু নোটিফাই করে দিলে ভালো হবে? না, না, এই যে পুরোনো অ্যাপিল, সেকেন্ড অ্যাপিল কে? না না, সেই সব ঠিক আছে, বলছি যে ওয়ার্নিং লিস্ট কোথায় রান করতো এমনি? ঠিক আছে। একই অর্ডার করে দিন। 31st করে দিন। থার্টি ফার্স্ট।
Well, 12 and
It-
13, Lord, I beg to appear for the petitioner in this matter.
And for the respondent.
I'm led by Lord Mr. Shaptangshu Basu.
এটাও অ্যাসাইন।
There are not two revisional applications.
হুম।
Lord, CO number 900 is against me, Lord, an order rejecting, Lord, to refusing to set aside an order, Lord, from taking the suit out of ex parte. And my lord, 904, my lord, is the revision, my lord, against rejection of my lord order 7 rule 11. My lord,
In both the
defendant-
cases, he was the petitioner.
Yes, in both the cases and the petition. The defendant number 1, my lord, is the petitioner of your lordship. In a suit for recovery of money on account of, my lord, certain services rendered. My lord, those are on account of, my lord, merits. Kindly comes to, my lord, 904 to the order implement. My scope of challenge in this
904.
revisional application is very limited. The issue is whether I can file a order 7 rule 11 application in a suit which has been fixed for ex parte, and to what extent the court can adjudicate not my
Unless-
application. Not Mr.
Take my break.
Mr. Basu is here, my lord.
দূর হয়েছে ওখান থেকে আসতে হয়
Sir, আপনি এবার Now, my lord, this is the issue with your lord. A limited issue. Kindly comes to the impugned order in 9041.
At page,
Lord, the last annexure, my lord, order number 20. Certified copy.
order number 27.
Yes. Kindly sees the manner in which it has been disposed. The court proceeds to hold that there is, my lord,
This suit is fixed for ex parte hearing against you,
yes,
unless this order is recalled. Could you file any application unless that order is recalled when the suit is posted for ex parte hearing? If yes,
It is posted for ex parte hearing. My written statement is not there. But whether the suit is maintainable or not.
that's fine. But Mr. Basu, the question is, suit is running ex parte. That means
Means I
you
am
are
debarred.
not on record.
No, I am on record. I am debarred from filing written statement and making my I can oral submission I can make. If I am there.
Yes, you can cross-examine
Yes.
subject to your appearance.
Yes.
First, you need to pray before the
My
court.
defense case need not be looked into.
No. How could you file an application under Order 7, Rule 11 unless this order by which the suit was posted for ex parte hearing is recalled?
Yes, I can. But this
You-
is the question
you-
my lord has to answer.
Yes.
Our contention is, so far as the ex parte board is concerned, I am debarred from
From anything.
no. I can do anything. I can cross-examine.
You can cross-examine provided ex parte order is not there. You are not allowed to file written. Suppose you are not allowed to file written statement. You are
Yes.
there in record.
Yes,
You can cross-examine. You cannot place your case.
I am not facing my case.
Oh, that is the rule. But when
Order 7 rule 11, am I pushing my case? No. Answer is no.
what's the consequence of ex parte posting a suit for ex
Because
parte hearing?
I should not be hard.
No, not you should not be heard. You did not appear before the court
Yes.
the day fixed for your appearance. So
So I
you didn't do anything.
very. Am I debarred from filing this application? What is the debarment?
First, you have to pray before the court, recall the order,
Application file করেছি না?
recall my order, accept the vokalatnama,
That
then
that is
the
my-
question of your written
No, no,
written
in
statement.
some cases, my vokalatnama filed, I initially appeared, thereafter don't appear.
Fine,
Same consequence.
same consequence.
So
You have to file an application before the trial
That is
court.
also there. That is
Where
also
is
there.
there?
The second matter. Two matters are there.
No.
That is also there.
Then we should take up the first one. Unless you cross the threshold, you cannot file this application.
That is will be academic. My learned friend is saying to argue on the point. Even without that, I can file. না এই কোটে মামলা করতে আমার ভালো লাগে
Yes. Then should we take up 900?
Hello?
Should we take up the earlier one?
Can you take up
That will be better.
900? Yes, yes. That will be, my lord need not go into this technicalities hurdle. If that is allowed, then automatic it comes.
It will go. Yes. Today is fixed for passing order on an application. Plaintiff filed a suit in this case.
My application, your lordship can look page 14.
Page.
Page 14 is in my application.
Okay, I'm going through the order impugned
Yes.
first. What is order 5, rule 1? Is there any embargo in respect of commercial suit? Mr. Basu? Order 5, rule 1, when the suit has been duly instituted, a summons may be issued to the defendant to appear on subject term to file a written statement and provided provided further. Where the defendant fails to file written statement within the said period of 30
But this
days.
is two
he shall
parts.
be-
One is written statement, one is taking up some expertise.
Yes, yes. No, while this rejecting your application
Then
to
there is a
recall the
bar.
order.
Court said there is a bar.
Yes, that is why I am going through this. I provided further that where the defendant fails to file written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reason to be recorded in, but which shall not later than 90 days from the date of service of summons. So, at best,
It is discretionary.
no, at best, court can say that, well, you can contest, but you cannot file written statement.
At best.
Yes,
But I say, my lord, this is also discretionary.
yes, to some extent, if we say so. So, your prayer to recall the order of by which
the court
suit
is there
was
also
posted.
rejected. And my application is at page 14. Can you see?
If this application is allowed, then you are well within your
Then, my lord,
jurisdiction to file the application under order 7, rule 11. So basically, this CO 900, the impugned order.
Can you once come to page 14, can you come my application?
Yes.
Can you once come to my lord, the
It was initially filed before the learned.
Yes, yes, regular suit. Thereafter, my lord,
Thereafter, it was transferred to.
that our case is, my lord, no notice was given to us. Those are the grounds we have stated in page 14, it starts. Then COVID story also there. Oh, yeah.
When did you receive the summon?
Someone, my lord,
You did not mention.
probably
It's there in the order.
in the order it is mentioned.
Yes.
Nineteenth March 2019 and 24th January 2019 by two trucks.
2019.
I can make short. Why
No,
I-
your point is very short.
No, I can make it shorter. Because
Okay,
this
make it.
point has no more racing, you got decided. So why I open this, so that I can get a chance to file my written statement also. I am very candid with you, because I am showing to Lordship the judgment. He is reported in 2014 to Calcutta Law Journal.
About extension of time to
No,
file
no, no,
written
no.
statement.
Even if I am expert board, order 7 should be heard first.
No, that is okay.
So-
I'm not on that.
First one is,
What I was telling you, unless you get this order recalled, you don't have the
No,
locus to file.
no, that is the private series. Private series, a very short judgment.
Yes. Which paragraph?
6 paragraphs altogether. Can I read it? More or less similar facts. Paragraph 5 is 11. Since the trial court has fixed the matter for expertise,
The matter was fixed for expertise
Keeping-
hearing after you filed the application.
but
There you had the locus. You appeared before the learned trial court.
on the date the matter is taken up, my locus standi goes.
Here, you received the summon.
Yes,
You appeared before the learned trial court.
Here the
You
same-
filed. No. Here,
I appeared.
Mr. Basu. Here, the case decided by.
Yes.
There, you entered into appearance.
My lord.
You filed your Vakalatnama coupled with an application for challenging the maintainability of the suit.
My lord.
Learned trial court, instead of taking up your application on the adjourned
The
date,
matter on expert board.
expert.
No, when the matter was taken up for expert board, as per the observation of my lord is observing. So my locus standi ceases. It is immaterial whether I have filed earlier or subsequent. And my lord knows, your lordship's court decision is there. I was arguing that even without application, court can look into it.
Yes, that is
So
always.
whether I have filed an application prior or post, subject to correction is no more relevant.
Absolutely, there is no issue.
So I raise this point only.
Yes.
So if that be so, my filing of application is not necessary. I can make this point before the court. And court is required to do it. Even in 227, my lord, one plaint has been rejected, reported judgment, oh, no application nowhere. In first time in 227, your lordships could take the cognizance, plaint is baseless, rejected. So no application. That's why my submission is this, my lord, facts of this case. If I am succeeding, my lord, in second revisional application, that I have materials which should have prompted the court to recall the ex parte vote, then I am through. If I am not, I am alternative submission. Even if, my lord, I am not through, that the suit is not taking out of the ex parte vote, then also, my lord, I have a right to say that the suit is not maintainable.
Fine.
Relying only on the plaint, nothing else. And my lord, no application is not necessary. So this application is
Yes,
nothing.
what he wants to
Want
draw.
to show again, you have to 1,51,057 times my lord has to see the order 711. He is
So what?
asking.
So what?
He is saying that there is no application contemplated. So without
No,
application,
without application, it can be done. The point is, do you have the locus when the suit is posted for ex parte hearing?
yes, this is the
According
point.
to you, this judgment
Helps me
supports, yes.
because the point which I am canvassing, whether it is ex parte or not ex parte, whether application or
No.
no application,
If it is ex parte, you cannot have any say unless the order is
if
recalled.
I can cross-examine, my lord, I can also file.
You can cross-examine
I am
only
not
when,
doing this thing.
only
I
when.
am not showing, my lord, kindly, pardon me. I am not saying anything of my defense.
You cannot, that is, to that extent I am with you. Only point is, so long the order of ex parte is there,
Can recall
You are
the-
due. you are to recall it,
Can
then-
recall it? Can you see the order? What is the application is there?
yes,
Application, I have put the grounds. for
I have
which
seen,
was
I have
given.
seen your application. What's the harm if I take up your 900 first and 904?
I want to keep both the,
Okay,
that's all.
fine.
Because- Yes, yes, sir.
To him, Millard.
বলতে পারিস
না। না কেন কেন এটা চলছে Lordship will kindly take the date of the order. So it's dated, my lord, 7th of January 2022.
Which one?
The impugned order.
Impugned order. Impugned order passed in CO 900 or 904?
CO 900.
900. Yes.
It's dated 7th of January 2022.
Yes.
We are today 28th of July 2023. So, Millard, in the main, it's not a question of his fault I am hearing. So, Millard, in the meantime, Millard, it is material what has happened. There was no stay. My learned friend could not get a stay. Whatever be the reasons, court could not take up. My learned friend could not get the matter listed. My learned friend was not here.
Suit has been disposed of.
Suit is now, no, suit has been hard ex parte, judgment reserved.
Judgment reserve.
Judgment
So it is still in the pipeline.
Yes.
So, Millard, what is the law, Millard, legally?
Hmm.
Can it be interfered with? Can it be interfered with at this stage? The answer is
Now
no.
you just
Now,
give
kindly,
me-
Millard, I just frame the point.
yes.
There are at least, Millard, 8 orders after this, which are not being challenged. Subsequent orders not being challenged. Suit has been posted for hearing. Finally, not that Millard, he was not there when the matter was. He had a chance. He did not apply that I should be allowed to cross-examine. That is not his application. So, Millard, suit goes to the board. He was not there. Examine, judgment reserved. So, in law, can he today maintain this application?
Where is the
Lordship
bar?
has to say.
Unless the suit is disposed of.
Kindly, Millard.
Only when the suit is disposed of, he can file application under order 9 or he can challenge it in an appeal. He is now in limbo.
Millard, may I, Millard, be permitted, Millard?
Yes, why not?
Millard, when the suit is judgment is reserved,
Hmm.
then Millard, the only option, Miller, is to wait for the decree. That's Miller. I do not say, Supreme Court says, Miller. Kindly have a look at 22 volume 5 SCC. On merits, I'll come back. I'm not shying away from it.
Do you have the
Yes, yes, I
copy
have
of judgment? Give it to.
I give a 2022 volume 5 Supreme Court cases 484.
2022 5 SCC.
কেউ আছে এখানে জজ সাহেবকে?
Yes. I Aditya. Page number
Millard, page number 484.
484.
Kindly have a look at para 94.
19.
94, 94.
94. Okay.
Nowadays, Millard, I can't say comment on anything, Millard, but Millard, we have Millard SCC going into Millard 17 volumes a year. In this respect, we'll refer to the, has my lord found it?
Yes, yes.
Observations made by this court in Arjun Singh versus Mohindra Kumar. Though the issue involved in the said course is distinct, the issue involved in the present case, we find that it will be apposite to seek guidance from the observation made in this court while considering the provision of Order 9, Rule 20 of the Code of Civil Procedure. The relevant extract reads thus. In the present context, once the hearing of the suit starts, the court contemplates two stages of trial, where the hearing is adjourned, where the hearing is completed. Here the hearing is completed. When the hearing is completed, the parties have no further rights or privileges. In the manner, it is only for the convenience of the court that under Order 20 Rule 1 permits a judgment to be delivered after interval of hearing is completed. It would therefore follow that after passing of the stage contemplated under Order 9 Rule 7 is passed in the next stage is only for the passing of the decree in terms of Order 9 Rule 6 of the court which court is competent to pass. And then follows the remedy of the party would have to set aside the decree by Order 9 Rule 30. There is no hiatus between two stages of reservation of judgment and pronouncing for hearing, so as to make it necessary for the court to afford a party the remedy of getting the order passed in the lines of Order 9 Rule 7, where we are therefore of the opinion that the civil judge was not competent to entertain an application dated 31/5/90 purporting to be under Order 9 Rule 7, and consequential reasons given in the order would not be res judicata to the bar of the petition under Order 9 Rule 30. Now, next paragraph, very important. It can be seen that this court in Arjun Singh has held that CPC contemplates two stages of trial. One, where the hearing is adjourned. Two, where the hearing is completed. I fall in the second. The hearing is completed.
Yes.
Hearing is completed. It has been held that where the hearing is completed, the parties have no further rights or privileges in the matter. It is only for convenience of the court under Order 20 Rule 1 permits a judgment to be delivered at the interval of hearing is completed. It has been held there is no hiatus between these two stages of reservation of the judgment and pronouncement of the judgment to make it necessary for the court to afford a party a remedy getting the order passed in line of Order 9 Rule 7. So
Now, sir, could you please apprise the court about the fact of the case decided?
yes, absolutely. Now, Millard,
Probably application post hearing.
Supreme Court is laying down the issue.
Right. No issue. Let us understand the fact.
Yes, kindly, Millard, take the facts of it. Kindly have, Millard, paragraph 4.
4.
Then, Millard, paragraph 10 and 12. So the facts are quite large, Millard, so I have to show, Millard. Then takes paragraph 22 and 24. Unfortunately, I don't have the Arjun Singh today. If Lordship wants, I can bring back the.
It's with us also. We can download and have a look at it. No issue.
I can do it here, Millard. It is confirmed.
So,
Now, Millard, kindly take para 31. If Lordship wants to read, I can read the entire thing,
No.
Millard. It's very thereafter the submissions and submissions. Then the
No,
ratio.
all I want to see whether the parties were before the court contesting the matter. Now, there are two things. In one case, suit is running ex parte,
Correct.
and in the other case, it's a contested suit. After closure of argument, when the case is reserved for judgment, you cannot file any application.
No, kindly, my lord,
Yes,
have a look at Order 9, Rule 7.
yes.
Lordship has looked at it many a times.
No, every time is a new experience.
Procedure where the defendant appears on the adjourned date and assigns good cause for his previous
I'm
non-appearance.
sorry. Yes.
That's Order 9, Rule 7.
Mm.
Now, my lord, how it proceeds, where the court has adjourned the hearing of the suit ex parte.
Mm.
Kindly take, my lord. So it's a Supreme Court is considering, Lordship has seen Order 9, Rule 7, considering a suit ex parte. That's Order 9, Rule 7. And the defendant at or before such hearing appears and assigns good reasons for his previous non-appearance.
Mm.
He may, upon such term as the court directs, as to the courts or otherwise, be heard in the answer to the suit as if he has appeared on the fixed day for his hearing.
Mm.
So, my lord, Supreme Court in no uncertain terms, my lord, it's saying, my lord, once a judgment is reserved, this is a ratio. My lord, unless, my lord, it is shown, my lord, that there is a, my lord, subject to correction, lordships will correct me if I am wrong, that there is a larger bench of the Supreme Court, contrary to this ratio, my lord. That applies. Now, my lord, on facts. So, my lord, on the question of maintainability. So, my lord, today, my lord, it will be an application in the nature of 151 is meaningless. We write 151. It's the nature of Order 9, Rule 7, 1 files. The specific procedure to take back it from the ex parte board under the code. In, I'm going to read it. Well, in no uncertain term, अरे बाबा एगुलो বাজায় কেন?
At the end of the day, your friend. Yes, you carry.
So, my lord, till paragraph 1992, my lord, paragraph 92, my lord, and 93, there is various.
You are on the
discussion
judgment.
On the judgment. The ratio, my lord, lordship will look at the ratio. Supreme
Yes.
Court is considering Order 9, Rule 20, Order 9, Rule 7. And what is the option to the party, my lord? It's in no uncertain term, it's laying down. It's a proposition of law under Article 140. Forget the fact. The fact defendant appeared, not appeared. My lord, fact, my lord,
Based on facts.
maybe, but my lord, it's a ratio, my lord, we cite. All cases can't be A, B, C, D, A, B, C, D. It will
But
be
rule of precedent says
yes,
it should be in
in the facts
parameter.
and circumstances. But if there is a clear ratio, I am also carrying it. My lord, court has to go by the ratio. It's a ratio of the judgment. It says, my lord, after the hearing is concluded, the remedy is to file Order 9, Rule 30. If it is against him, my lord, even ex parte suits can be dismissed. No, judgment is reserved. I have the order, sir.
Not delivered.
Made immaterial, my lord. I place it for my satisfaction again. I do not. If your lordship wants, I place it again. In this respect, we refer to the observation made by this court in Arjun Singh versus Mohindra Kumar. Though the issue involved in the said case is distinct than the issue involved in the present case, we find it apposite to seek guidance and observation made by the court while constitute the provision of Order 9, Rule 20 of the court. The relevant extract reads as follows. In the present case, once the hearing of the suit starts, so my lord, it doesn't, my lord, make a distinction between an ex parte hearing or a, my lord, contested hearing. The court contemplates two stages of trial. One, where the hearing is adjourned. Two, where the hearing is completed.
Yes.
Where the hearing is completed, the parties have no further rights or privileges in the matter, and it is for only the convenience of the court that Order 20, Rule 1 permits the judgment to be delivered after interval and after hearing is contemplated it would therefore follow that after the stage contemplated under Order 9, Rule 7 is passed in the next stage is only of passing of a decree, which on the terms of Order 9, Rule 6, the court is competent to pass.
Yes.
And then it follows the remedy of the party to have the decree set aside by filing Order 9, Rule 30. That there is no hiatus between the two stages of reservation of the judgment and pronouncing the judgment. In the pipeline, the phrase used is immaterial. So as
Yes.
necessary to the court to afford a hearing in the lines of Order 9, Rule 7, therefore we have no opinion that the civil judge was not competent. This is below Arjun Singh.
Yes,
To
yes.
entertain an application purporting under Order 9, Rule 7 and consequential reasons given for the order of res judicata such and such. So there is 151. Now, Millard, look at Millard, the conduct.
Conduct is not that relevant.
Absolutely.
It was considered
Not
by
that-
learned trial court.
Not that, Millard. Absolutely, Millard. Kindly have a look at the orders. How many orders he have passed? After your application got dismissed, how many times the judges, honorable judge, gave him the opportunity to take a stay order from the court?
Stay order.
Yes. He went there and said, please don't pass a judgment. Give me, hold the judgment. Yes. Time. Millard, kindly
Yes, I
take.
can do. I approached the court, one day it has taken up for hearing.
Should have not examined.
Thereafter it was assigned. Could not be heard by the regular bench.
Millard, kindly, Millard, this is Millard. Millard, from order number 28 to order number 32, regular
No,
adjustment,
Mr. Ghosh,
Lordship.
if this in view of this Arjun Singh, Mr. Basu, I think there is a real difficulty how to tide over this. Judicial discipline shall not permit me to take any other course. So better you go through the judgment and make your submission.
This judgment, but I could not find the facts.
আমি
within
বলে
Article
দেবো,
law.
আমি আপনার কাছে এসে বলে দেবো, স্যার আপনার কাছে কাজ শিখেছি, আপনার কাছে নিয়ে এসে।
So I have
He
nothing
can't
to
deny
say.
anything that the appellate side work I learned from him and Jivan Ratan Chatterjee. He can't. I did not have any
It's-
matter in the
it's-
original side, I had matter in the appellate side.
It's very specific. It's very specific. Once the hearing is concluded, there is no room to invoke the provision of Rule 7 under Order 9.
Not invoked. Not
Yes.
invoked.
No, there is no room. That is what,
There is no
According-
invocation. There is no invocation of any proceeding, initiation, anything post CAB. Nothing. These are all pre-CAB.
So today it can't be done. Today it has reached a final stage. That's the problem.
So-
That were there
when the suit was posted for CAB,
CAB.
What
First
was
April
Supreme Court times without
First
number
April.
saying that
First April
I
23.
cannot be remediless.
Yes,
and when this revisional application was filed.
March 22. So if you don't get a stay, naturally it will proceed. Millard, it
cannot
was
pro-
right.
I cannot
Deepest of
procure stay.
respect. It was the deepest of respect, my lord. This is not a correct submission, at least from him. Court number 7 said Millard, of the view, Millard, 227 will not lie in respect of a petition filed by the commercial court. So I'll not stay the
Yes.
order.
Yes,
I'll not stay the order.
that.
So Millard, that
point
court goes.
That point goes now.
Oh, I'll argue that point. I have not argued that point. It's a self-imposed bar. You cannot, in view of section 5.
Good. Let
Section
me
5 of
argue
the
that
Commercial
point.
Code Act.
Yes, I'll argue that point.
Show me.
Do that.
Is my learned friend accepting this proposition?
No, not at all.
That is
Facts
the-
are different.
Yes, you read that and make it the next day. না আমি তো বলছি না আজকে সবচেয়ে 18ই সেপ্টেম্বর ম্যাটার আছে।
Then tomorrow if the judgment is delivered, gone. I'm
18
gone.
September he is not, he doesn't. আমি কোনো
No, let me go through section 5 of the
Yes, have a
Commercial
look at section 5.
Code. Yes, please read it for us.
227 is not a bar, it's a self-imposed
That
restraint.
that point, Malone, settled now.
Yes, it's a self-imposed restraint. Section 8, Millard. Kindly have a look at section 8.
Section 8.
8. You should not entertain unless, Millard, you are compelled to do. Bar against revision petition or petition against an interlocutory order. Notwithstanding anything contained in any law for the timing in force, no revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction, or any appeal challenge subject to the provision of section 13 shall be raised only in appeal against a decree of the commercial court. But 227, my lord, I do not say we will jump up. 227 cannot. 227 will lie, but very sparingly, only in limited circumstances, self-imposed restraint. This is on commercial court, my lord, I have, my lord.
Yes.
He is not remediless. He will file order 9, rule 13. Summons, he was served for summons twice. He did not appear. I did not appear. So this is weighing on the court. I'll show the facts. If Lordship wants today, I want to show it today. No difficulty. If he wants to come back with the judgment, he can come back. I'll come back with Arjun Singh also. Arjun Singh was a case which was after this he filed an application.
So for the first point, I hear now maintainability.
Maintainability of
You
your
have to decide. Yes.
revision. No, that
Now
is
that is
the,
settled law.
I'm not on that.
It's also.
I want to dispose of the,
Sparingly.
I want to dispose of the application. You have finished your argument.
This is my subject.
Now let Mr. Ghosh complete.
Maintainability, I'm not answering because maintainability, according to me, my lord, it is now settled by just division bench of Justice Holy Standard.
Now, my lord, kindly, my lord, have, my lord, the facts of the case. Facts of the case. Kindly look at his application once. Kindly look at his application, which is page 14.
Page 14.
14.
Yes.
My lord, ground should be what, not today, what is urged. My lord, kindly have a look at page 15. It's an application under section 151 of the Code of Civil Procedure. My lord, this is, my lord, with deepest of respect, my lord, the court doesn't, my lord, contemplate an inherent, my lord, 151 application when there is a specific provision. So I take it under order 9, rule 7, whatever be the stage. The suit has, my lord, this suit is filed. The defendant number 3, kindly take para 3. The defendant number 3, being aware of the instant suit, appointed his learned advocate to take steps in the matter. Unfortunately, owing to the chamber shifting of the advocate and the file and the brief of the defendant number 1 was misplaced. In addition to the misfortune, the clerk of the advocate completely lost the track of the matter and could not follow up the matter. In the meantime, the defendant number 1, having entrusted with the entire matter, was of the notion that necessary steps were being taken. Upon a routine inquiry, the defendant number 1 came to learn that the learned advocate has lost the whereabouts and as such could not follow the suit.
Yes.
Forthwith, the brief was taken back from the advocate, who, and another learned advocate was entrusted sometime in the month of June 2019. Immediately after handing over the brief, the defendant duly instructed the advocate to take expeditious steps, and several searches was unable to trace any suit. In the meantime, so 2019, COVID came in March 2020. Pandemic intervened and entire setup collapsed. The defendant number 1, frustrated with the situation, engaged with the present advocate. Upon due of the available information, it was discovered for the first time in July 21 that the instant suit was transferred before the learned court. Going through the record, it has been found that the suit was transferred on 3rd July 2019. Unfortunately, this is his only ground. Unfortunately, after transfer, no such notice was served on the defendant. It is for the first time in the month of July 21 that the defendant number 1 has come to learn about the whereabouts of the suit. It is discovered that the suit has been posted for ex parte hearing when 20th September 2019. The first day of the hearing. Forthwith, the defendant instructs his advocate to take appropriate step according to defendant advice to take out the present application for removal of the ex parte degree on board, thereby enabling the defendant to contest the suit. In any event, the suit is at the nascent stage and no progress have been taken. Since the suit, it has also been found the last date was fixed on such and such. So this is all his case, and not only that, Millard, he says, Millard, he has not put forward his case at this juncture. Para 9. It is an admitted fact there is no privity of contract between the plaintiff and the defendant number 1 IPCL. The plaintiff intentionally and deliberately added defendant number 1 in the instant suit. We further state that video order dated 7/11/2019 passed by NCLT bench in CPIB, the application of State Bank of India, financial creditor defendant number 2 filed under section 7 has been admitted, and Ravi Shankar such and such has been appointed as the interim resolution professional. The suit has been lodged against the plaintiff before the resolution was therefore in view of the same the instant suit is not met. That is his case. The defendant number 2 is in insolvency. How could you proceed again only against the defendant number 1? So your suit is not maintainable. Now I deleted defendant number below 2 because I cannot proceed against the defendant number 1 under the Insolvency Act below. Under section 14 there too, there's a moratorium. So I said, I don't want a degree. Delete the defendant. I proceed against the defendant now jointly and severally liable. Now, my lord, kindly now takes my affidavit now.
That point I leave. I don't want to dilate on that point. I
That's
don't
his
want
case.
to. Yes.
That's on
My-
the merits, sir.
Yes.
What is his
My
argument?
consideration will be
What
very
is-
limited.
What is the argument? Argument is not summons were not served. Argument is his lawyer, my lord, lost the file. Papers, everything, client could not trace. My lord, the act doesn't contemplate, my lord. I'll show the section. If a summons is served and the matter is transferred again to a commercial division, fresh notice has to be given. It doesn't contemplate under the act. I am fortified by a judgment of the Bombay High Court, which Madras High Court, which says, my lord, it's a judicial, my lord, pronouncement.
There is one civil rules and orders which prescribes in such a situation when a case recorder suit is being transferred from one court to another, not by any judicial order, by administrative order, then the parties through their lawyers must be notified.
Here it's, my lord, it doesn't apply because it's under the act. It's not an administrative order. It's an administrative order. The act,
The tribunal, non-tribunal, all transfer, notice has to be given.
it has to be a government notification. It's not necessary.
Government notification relating to creation of the court, Mr. Ghosh.
With
Government
request of-
cannot have any say.
What
on-
Lordship is saying, my lord,
Yes,
my lord, it's not provided. This act provides, it's a commercial
that's
suit.
fine.
It's a case management hearing. If the court feels,
First, there has to have some cases.
yes,
Now, here in this case,
yes,
in this particular matter, cases are being transferred from a regular court to commercial. court.
commercial court
Fine.
under the
Under
provision
the
of
act. Fine. Now, CRO is applicable. CRO is something different, like your appellate court rule, appellate side rules, original side rules. It runs parallelly.
may not
You
be,
you
my lord.
always read CPC read with provision of certain provision of your
Correct.
appellate side or original side rule. It's like that. Object is no one should be taken by surprise. Please notify that your suit is
where-
being transferred from here
I
to
answer
there.
it. Where is the question of surprise?
That is the object of that provision.
Yes,
When you are transferring, notify the party.
yes. Now, my lord, if it is under the act, what is the consequence, my lord?
Yes.
Kindly, my lord, take, my lord, I rely upon, kindly take the act once. As a
Yes,
commercial court act,
yes, yes.
have look at the commercial court act. Kindly take, it's a transfer under operation of law,
Section
section 15, by operation of law.
15.
Like, my lord, proceedings are in this court. Normal suits were transferred to DRT under section 19, under operation of law,
Transfer of pending cases. Fine.
pending suits.
Yeah, pending suits. No, transfer of
all
pending
suits.
cases. Yes.
All suits and applications
Hmm.
including application under the Arbitration Conciliation Act relating to a commercial dispute of a specified value pending in a high court, where the commercial division has been constituted, shall be transferred to a commercial division. Next, all suits and application, including the application or subsection 2 of the Act, and the Act shall apply to those procedures that were not contemplated at the time of transfer. So, moment the Act comes in, Millard, the old Act, anything will not apply. It's a simplicitous transfer. So, Millard, civil rules and orders will not apply.
Very well.
That's Millard 3. The commercial division or the commercial court, as the case may be, may hold case management hearing in respect of transfer suit or the application in order to prescribe new time limits or issues of further direction that may be necessary for a speedy and efficacious disposal of the suit in accordance with order 15A of the Code of Civil Procedure. Provided the proviso to Rule 1 of Rule 5 of the Civil Procedure shall not apply to transfer suit of the application, and the court may in its description prescribe new time limits within such time the written statement must be filed. So, Millard, if someone comes, Millard, he may be given a time. In the event the suit or application is not transferred, the commercial appellate court may transfer. So, Millard, transfer is by operation of law.
Yes.
And Millard, as on date of notification of this, Millard, anything under the old Act will not apply. This is Millard subsection 3. And Millard, this transferred, Millard, happened in 2019. They came in 2021. I have the notification of Millard, the Millard Setting Up of Commercial Courts Act, which is Millard, page 67 of 900 of Millard CO 900. Sixty-seven. তোমাদের 900 এর 67. This is Millard, 2nd of July 2019. This is for the information of the all concerned, including the judges designate of the 4 commercial court temporarily indicated at Alipur, Asansol, Rajarhat, Siliguri, that the Honorable Chief Justice of the High Court has been pleased to inaugurate the commercial court to process the honorable judges they designate on 5th July, such and such, such and such. So it was set up and it got transferred.
Yes.
He says, Millard, he has no knowledge of setting up or transfer, and he searched the records of those courts and he could not found. That's his case. But in law, that is, Millard, permissible or not? Kindly, Millard, have a look at. This is, I'll give my learned friend a copy. Copy আছে শতাংশ। এই শতাংশ সাইট করছি কপিটা দাও। ওই আমি বুঝতে পারি না সব সাইটেশন দিয়েছি তো, কপি দিয়েছি তো তোমার হাতে, সাইটেশন দিয়ে কি করবে? আচ্ছা, আমার কপি কাইন্ডলি হ্যাভ আ লুক এট। এটা আমার মাদ্রাস ল তো আছে, নামটা মারলি তো এসএস থেকে পাবে, বলছি। Kindly, my lord, take paragraph 29. Now, if the statute prescribes a transfer, what is the effect in law? 29, sir. This in fact is relied upon, my lord, in the trial court judgment. It is argued that after the suit, he argued that the suit, after it was transferred to city civil court, is a fresh suit and a different from the suit which was pending in the court of the original side. The learned counsel of the respondent contends the summons should have been issued afresh in the suit and it has to be renumbered in the city civil court. This is the argument. According to him, at any rate, the notice should have been issued directed by the court to the counsel. On the facts, I have already had the version of the respondent is unavailable and accepted R6 and R5 held notices were issued to the respondent himself by the petitioner's counsel. There is no denial that he did not receive the summons on 2 dates in this case. But with regard to the contention that the suit is a fresh one and the summons should have been issued afresh, there is no warrant whatsoever either by the civil procedure code or the civil
Perhaps,
rules
Mr.
or practice.
Ghosh,
Yes.
sorry, perhaps this is not the case make out by the petition.
That is his case, my lord. No, that is your case. If you are not facing, notice of the suit.
He is indicating notice of transfer, which according to section 15,
Kindly, my lord, have a look at, let me place it the next paragraph. It quotes so and is holds, my lord.
yes,
This is, my lord, some say notice not served. I forget, my lord, summons here, no notice. Kindly, my lord, takes the next paragraph.
yes.
In the present case,
Hmm.
of transfer is not by an act of court.
Hmm.
As lordship is saying, my lord, administrative transfer. The transfer is a statutory transfer pursuant to the provision of section 34 of the Tamil Nadu Act of 1980. Under the act, the pecuniary jurisdiction of city civil court as well as the subordinate court was increased by act of such and such. Now, my lord, this is quoted. In the suit pending in the High Court on date of the commencement of the act, which would be within the cognizance of Madras City Civil Court, as amended by the act, shall stand transferred to the Madras City Civil Court. This is by operation
That is
of
your
law.
section 15.
So I did
That
not
is
give
why
any
I'm
notice. I did not give any notice at all. This is what the court is saying.
What you are trying to make,
Yes.
it's there in section 15,
Yes.
which
so
is why
fresh
I'm saying what's the
notice is not-
point of this judgment?
That's the judgment says the statutory transfer, no fresh notice is required.
That is section 15 as well.
Yes.
Fine.
That's kindly, my lord, read. I am not placing it. Lordship is under a lot of pressure, my lord. Kindly take from thus to paragraph 30. আমি পড়লে তো সময় লাগবে জজ সাহেব থেকে নেবে। The statute itself is a notice. That is the Madras saying, my lord, same provision, same shall DRT also, my lord,
Yes,
section
yes.
19. I did not go, my lord, to the defendant or the department sends a notice. So this is the fact scenario of the case. Today the judgment has been reserved. আর কিছু দেখানোর আছে মোবাইল? So, my lord, in view thereof, my lord, there is no question of interference in this order. This is my summary.
Fine.
If he wants to cite any judgment, I'll only distinguish. He's carrying a book. I am very afraid. আমি কি বার করে দেবো ডাউনলোড করে দেবো তোমার আরে এখন তো বাইরে থেকে বই আনবেন
To answer is,
These are my
I'll make little broader aspect. But what is civil procedure code? Civil procedure code, the framework of the civil procedure code thought that this should be the paraphernalia, keeping in mind the natural justice. No person should be complain that he has not been heard. A lease is against him, he should be heard.
But what about misuse of liberty or opportunity? That is also a point to be taken into
That
consideration.
can be compensated by cost. Your lordships, there are so many judgment is there that if we were not prejudiced, irreparable loss, then it can be compensated by cost. Now, my lord, here, this is a statute.
Hmm.
If the statute expressly not barred of notice, had it been a case, the court, the statute says under section 15, no notice is necessary. I could understand. Otherwise, my lord, the royal lord knows. In writ jurisdiction, we normally cited this judgment. If it is not expressly taken away, natural justice has to read into it. So, my lord, I don't know. A notification has been published. Matter transferred. But how I know? I'm not an astrologer. So this is, I know my lord will not be going to that aspect now because
Which one?
my lord, your lordship will considering my application for
Only that, I am not getting into the merit of your application
Right.
under order 7
right,
11.
right. Now, my lord, this question
Only
may
the
be
order
answered.
impugned.
এটা দিয়ে দে, প্যারাগ্রাফটা দিয়ে দে। এটা 2008-12 Supreme Court cases in response to your Madras judgment. দিয়ে দে না। কবে আছে? আমি দিয়ে দিচ্ছি, এক্ষুনি দিয়ে দিচ্ছি।
2008, volume 12.
This was transferred under a pecuniary jurisdiction. That is also under statute.
Yes.
That is under statute. If it is, my lord, here in West Bengal, under the Bengal Bihar Agra Assam Act. So this is also under a statute. Supreme Court says no, it is, but it goes without saying. And I repeat, my lord, the statute does not prohibit notice. If it is not there, your lordship has to read into it. That a noting is contemplated there. That is one of my ground. Because in this matter, I will not raise my voice. Because I am receiving it. Here, my lord, my prayer is, my lord, can you allow me? These are the grounds I have stated in my petition. According to my humble submission, other side will not be prejudiced. So these lapses, I use the word lapses, can be condoned by
Tell me.
compensatory.
Tell me only on this observation of Honorable Apex Court.
My lord.
I have to go through the entire judgment to understand the fact, but what
Fact, my lord, I had it.
what is being highlighted by Mr. Ghosh?
Yes.
The judgment is clear enough that after the hearing is over and the
তারপরে decree হয়ে গেলে মুশকিল হয়।
order is, yes,
But he is saying পড়ে এসো একদিন। In the meantime, decree is
I
passed.
mean, why I steal a march on him, Millard? 18 September is the date. Why should I?
18th September is the date for
For passing judgment.
18th September.
Yes. Why, Millard? He today
It's
found the fancy.
Then, my lord,
6 September found the fancy for this.
and it's a commercial,
আমি সোমবার আসতে পারবো না, মঙ্গলবার করবো।
it's a commercial suit.
Yes, he fixes, Millard. The commercial suit 3 years finished. I will know that.
Then what's the point?
problem is, my lord, the live streaming. I cannot say anything. All the tribunal courts
Anyway,
established for this purpose frustrated totally.
ঠিক আছে, আছে, শেষ করে দাও, হয়ে গেছে।
No, Malus query
No,
something. Some query
only
of-
thing is, the judgment is very clear. When the suit is posted for order after hearing or judgment,
Fine.
whatever,
Fine.
there is no room to set the
File any
clock
application.
back to file any application
I am not filing an application.
under order 9/7.
Only under.
Yes, that is a bar.
I
According to
think that is
this,
a bar.
according to this judgment. Now here factually, the difference is when you preferred this application under 227, it was for further argument or something like that.
Further argument. Further argument.
In such a situation,
Yes,
whether this embargo
will apply
will apply.
because examination is closed. It was fixed for hearing. Millard, could it be, Millard? Today, Millard, you file it. You cannot set back the clock. Today, Millard, it's a continuation of that proceedings, maybe 227.
No, I am not on 227. I am on
It's
the
a continuation of his order. He has lost in one court, his application coming up in other court. So Lordship has to see what is the present status today. And his
that is the
subsequent
point.
order.
No,
What should be the,
my lord knows when an order is passed and that been appealed against, that order loses its finality.
It's actually be a stay, Millard. There's a
No,
recent Supreme Court. I
It
can
loses
cite
its
it.
finality.
It's a writ
This is
judgment.
division bench judgment of
Everything
Justice
is at large. Now it says everything is at large. That has now been clarified. 1993 Supreme Court, unless stay, Millard, findings remain, Millard, thereeafter everything is large, back is 1993 Supreme Court. So that is, you are not remediless.
This
You can
cannot
file.
be a proposition of law.
Yes.
No, what
I'll show.
Mr. Ghosh is suggesting, if it goes against you, you can file order 9/2/30,
30. He can
or
do
you
that.
can go for appeal.
Orderly rule 30, my lord, I cannot because someone has been served the main ground. So I have to go for appeal. Appeal without any, my lord, remedy. I could not file written statement,
And
I
my
could
lord,
not do
most
anything.
interestingly, my lord,
So
since
totally debarred.
when he came in 2019, cross-examination already over. Our examination is already over.
No.
Summon service is
Everything done. Miller,
90.
kindly look at the cost, kindly look at the
Mr.
cost title.
Ghosh,
I don't want to
I-
argue the fact. Kindly have a look at the cost title once.
Cost
Have
title?
a look, have a look. This is, the matter is now over. Look at the defendant number.
No, matter is not.
prominent.
Look at, Millard, India Power Corporation Sector 5. The
So-
commercial code is in Rajarat.
So-
I'll show Millard, they have other matters in the list in that code. So, Millard, that one litigant who has other matters in that court, he will, Millard, take this benefit, he has no knowledge.
The moment summons are, we are appearing there.
Where? So, Millard, you
This-
watch from the
These are
bush. What is-
prejudicial fact, my lord. to
Kindly
what
look at the
prejudice,
name.
my lord.
Why, Millard, there is urgency? He's in NCLT also. Any date, Millard, section 9 will be, Millard, pressed into operation.
Let's be done. We are not there. My
Yes,
lord,
you don't
need
pay
to
anyone.
look Anything. But so far as this judgment is concerned, my lord,
That,
I
Millard,
find.
can't be touched.
Would you like to come back, or you
No,
want
I
to
have
finish
nothing
it
more
off?
to add.
Then,
I
my
have
lord,
nothing.
once let me go through this judgment.
Tuesday.
Tuesday, my lord, that matter is there.
Yes, then suggested it.
Thursday. And since morning to evening, my lord, you will not able to
No, no.
tolerate me. It is not. It is more than your lordship's capacity to tolerate me so long.
Lordship has heard me enough. I may cite Millard with what is Millard subsequently Millard. Anything Millard on this, whether the court can touch after.
Very
the
well,
application.
you can serve a copy upon.
I'll only look to this judgment and make my.
No, if he wants to file, cite any other judgment,
আমাকে বলে
just have a look.
বলে দেবো। আজকে তো হবে আমি বুঝতে পারি না।
ঠিক আছে।
তাহলে থেকে মামলা।
Can it be
So Tuesday,
on a Tuesday, my lord? That
then
26th.
26 কি করছে?
Thursday.
Thursday, হ্যাঁ, Thursday. না, Thursday না, 27th is a Thursday.
বাবা ঠিক করে।
করে দাও, বুধবারই করো। বুধবার বা শুক্রবার, 28th করো সকালে।
Arjun,
হ্যাঁ?
heard Mr. Basu, learned counsel, learned senior counsel representing the petitioner, and Mr. Ghosh, learned counsel for the opposite party. Let the matter be listed on 28th of July under the heading parted. Parted.
I'm afraid of Mr. Ghosh's softness. He's so soft.
এত
না,
জোরে
না,
মেলা করলাম। কি বলছো তুমি?
তো জন্মদিন থেকে তো চিনি। যা।
Grateful.
Whose book is this? Now, your 904 is absolutely dependent on the fate of 900.
I was thinking
If you
otherwise,
can, yes, if you can sell through 900,
then it is clear, everything, nothing, I have to not to
it's a
argue.
matter of course. If you cannot, then
Then solve them.
এই জাজমেন্টটা খালি
In a transfer.
আমাকে দিবেন না?
Timeline is running.
Anything required, man?
no,
Photocopy গুলো আছে তো দর্শন। Grateful. মাচো।
call the list. দেখুন। হ্যাঁ, ডেকে দিন। 11টা তো বলছি না, কি করবো শরীর? হ্যাঁ, ঠিক আছে। Appeal is accepted. Judgment impugned is set aside. Judgment by learned trial court is restored. Yes. Next.
Lord, yesterday your lordship.
Yes. Do you have the copy of
Yes. Deed. Kalidas. দেখতে পাচ্ছ না?
and tell me what is the status of the suit before the trial court?
But completed.
Completed means execution is over.
Execution has not done, my lord. But final degree has.
Final degree is okay. Final degree is not end of everything. What about execution? Final degree is to be executed for the purpose of delivery of possession in terms of the.
Possession has not been handed over to my client, my.
So it is pending. There is no execution
Lord,
procedure
it has been done. I'm told that it has been done. Possession has been given.
given by way of execution.
No, my lord, forcefully, my lord. That has been
That
my lord,
Forcefully
complaint before police authority, my lord, that has been not
No,
delivered.
who has
to my
filed this application for execution?
এই commission হলো পাইলো।
Who has filed this execution application?
We have not filed, my lord.
কেউ দেখো। আছে কিছু খবর? Lord, kindly see the deed, schedule and in the middle of the deed also, recital. দোকান ঘর 255 দাগে দোকান ঘর 100 আপনার in the record of right also দোকান it has been recorded.
Mr. Ghosh, can I have a photocopy of this document? Hey, এটা একটু দিয়ে দিন না ওনাকে।
Yes, এটা দেবা পারো তাহলে দুটো কি করে হবে এটা বলেন kindly similar the
And this copy of your execution application.
okay.
Where is Mr. Banerjee?
Yeah, appearing in code number 6, my lord.
My lord, kindly see the photographs.
Photographs.
Present.
দোকান ঘর the business place.
Present photo.
This is the suit property.
Yes, all the in the marketplace the all the three rooms, three sub-rooms. Then
This is the suit house.
Presently, my lord.
Presently means
At present, my lord. Opposite party, my lord, that my learned friends client, my lord, forcefully had.
forcefully. But at the time of purchase, there was
My
dokan ghar and go
client
down.
is nothing, my lord, in this property. 94 years old, petitioner, and his wife is for 90 years old.
there
Nothing, my lord.
there are three
Total building has been
dismantled and reconstructed.
my lord. Total building has been.
Lord, when we have purchased,
You had
sub-room with go down.
you have not been given any share in the
In
building.
this here, nothing, my lord. In this building, I have nothing.
Then what is your dwelling place?
My lord.
Where what is your
Another place, my lord, in a tile shed, my lord. They are living, my lord. Both of them.
Lord, in the photograph, your lordship sends a Samparko, that is his sub-room.
No,
Samparko
my
is
lord.
his
Sampark is another.
Yes, whatever it is.
SIDDHARTHA is not-
execution petition, copy of execution petition.
Nahi.
It is not there.
According to my client, my lord's execution has not done.
No, no, they are saying they have filed application.
I don't know.
আচ্ছা না যদি না হয়ে থাকে তাহলে বলো এক্সিকিউশন হয়েছে জানো তাহলে কেন বলছো পজিশন তো
Position
আছে
file has-
there is no difficulty.
My client was complained before the police authority that he had totally.
That is not. Lord, this is one aspect, Lord, your lordship just rightly pointed out that it is no longer a residential house, family dwelling house. And second point is, Lord, from all the applications and Lord pleadings,
My lord, only.
nowhere it has been claimed that I should be given separate allotment. Nowhere. That is the finding of by learned courts below, both the courts below.
My lord, kindly see
Therefore, Lord, in
page
view of the
31.
judgment,
Wait, why can't you
Hey,
wait?
my lord,
Let him
sorry.
finish.
therefore, Lord, by the judgment of the Honorable Apex Court, it has been held that from the time of filing of the suit till execution,
You
If-
are referring to Gautam Pal.
Gautam Par. Lord, paragraph 23-24. Kindly read, Lord. Your lordship has.
There
read.
are other judgments, Mr. Ghosh.
Yes, other judgments.
I am interested to know about the execution proceeding. That is the reason.
And Lord, as it is not a dwelling house, it is reflects from the deed itself. Therefore, Lord, there is no question of claims.
My kindly see.
Yes.
Only page 31, my lord.
31, yes.
My lord, last, my lord, the order in view of the ingredients of section 4, my section 4 application has been
Yes.
dismissed on that, only on that ground. Of the Partition Act and the aforesaid decision, it can be opined that the provisions of section 4 of the Partition Act are applicable in cases where a stranger transferring moves or sues for partition. However, in the instant case, the co-sharer has moved the application under section 4 of the Partition Act 1893 and on his own, and the stranger transferee has not taken any action for partition of the suit property at this stage, and elements of section 4 of the Partition Act is not applicable in this case of co-sharer.
That is the
Only,
statute.
only on this point, my lord,
That is the statute.
my lord. But,
Only
my lord,
when,
my lord,
only when the stranger purchaser seeks partition, you acquire the right to seek preemption.
my,
Why I am asking for this execution case? It's a continuation. If it is found that the stranger purchaser has put the decree into execution, then you can again, as co-sharer, make your claim.
Yes.
no, my lord,
No, my lord.
subject to my lord. So, my lord, kindly see the order dated 26 September 2012, my lord.
Yes,
Honorable Justice Homenson's order, my lord,
yes,
where
that is an interlocutory order, and there this point did not urge.
that, my lord, my stand was that opposite party.
Look, statute is very clear. Only when the stranger purchaser, in respect of a dwelling house, seeks partition, it gives you the right.
My lord, he seeks partition. Because,
Where is that?
my lord, he has filed for addition of party in this matter and he has contested as a applicant.
That will not,
My lord.
that will not help you. You go back, all I can do, if you can go back and show me that execution is pending and it was at the instance of the stranger purchaser, then you have some respite. Otherwise not. Then also, the nature is not dwelling house. That is another difficulty. It is applicable only in case of dwelling house. A commercial building will not any of that benefit to you.
Lord, just now I am told by the client is here, no execution case as yet will find. My learned friend is bothered, it
Even if the execution case is there,
has not been filed.
he has purchased a building with shop.
Stop and go down.
Even you cannot get the benefit of section 44.
Yes, to throw out under section 41 OTPA.
The co-sharer who sold the property, he was running the shop. He was running the shop.
Lord, he was initially a tenant running the shop.
Then he
Subsequent-
purchased.
Then he purchased.
Statute does not permit you If you can come back and show me that yes, though there is a shop, it can be considered as dwelling house, then there is something otherwise. We cannot go beyond statute. ম্যাডাম কালকে ওটা আপলোড হয়ে গেছিল। বুঝতে পেরেছি, আমি আসলে ডিকটেশন দিচ্ছিলাম তো ওই জন্য দেরি হয়ে গেছে। Heard Mr. Ghosh and you are Mr. Bapin Boiddo, learned counsel representing the parties. Reserved for judgment.
Okay.
এই মিস ঘোষ কোথায় গেলেন? ভদ্রলোক চলে গেছেন। এর রেবা পল, রাজেন্দ্র প্রসাদ, কালিদাস পল। Who is this Rajendra Prasad? Opposite party in item number 16, Rajendra Prasad. You don't know that you were representing. No. Yes, I am talking about the opposite parties only. Call the list. Call the list. Then.
My lord, Mrs. Kakuli Samashpati is representing.
She's my junior, junior.
She is your junior.
Yeah, honor.
Hold your breath. Take your seat. Take
You
your seat.
want-
I am passing over the matter. After 5 minutes, I shall take up. Call the next one. Next. Sit it. You are for the appellant.
Lord, 22, Lord.
We are on 25.
Lord, kindly make it not today, Lord. The learned advocate on record has not come today. He has gone to for his treatment. The Lord should kindly make it not to. 22. Good.
আমার মতো না তখন আপনি কি বললেন তখন এসেছিল একটু দেখুন না হ্যাঁ
In paper book that
Lord, NCR of this, Lord, we have submitted our special messenger.
who represented the appellant at the time of admission?
Lord, I have represented.
What was the order of the Honorable Division Bench?
In the paper book?
No. regarding LCR.
Kindly take page 48.
Be transmitted to this court by special messenger. এই এটা LCR আসেনি কেন বলছেন? আসেনি? কেন? মুশকিল হয়েছে। Was the suit for?
Their suit seeking rectification of a deed. My lord, this is the
Rectification of
second
a
round
deed.
of litigation.
Hmm.
Earlier, my learned senior friend had moved a second appeal.
Hmm.
In the second appeal, an order of remand was passed.
Hmm.
Thereafter, the appellate court, my lord, proceeded, and my lord had dismissed the appeal pursuant to the direction of this honorable court. The first appellate court dismissed their appeal. Against that, they have come.
Lord, the point before your lordship is this, that the
আদিত্য দেখুন তো LCR কি-
application for amendment
আসেনি।
was filed. Application for amendment of the replacement was filed in appeal, incorporating the prayer or rectification of the deed in terms of section 26 of the Specific Relief Act.
Hmm.
Now, my lord, the common mistakes and other facts, my lord, were allowed, but the appellate court did not allow to adduce evidence after the amendment.
What is your CAN 1? Is it still pending?
Can one, my lord, is for the purpose of staying the proceeding, and that injunction, an injunction was granted
So it has been disposed of.
till 28/7.
No, CAN 1 is pending.
Pending.
My lord, on the earlier occasion,
Hmm.
your lordship will find your lordship's order dated
আর department to দেখুন তো LCR
June 5, 2023.
Hmm.
My lord has found the interim order has been extended, and my learned senior friend was directed to inform us about the hearing of the instant appeal.
Hmm, hmm.
And interim
My lord, I
order
stand corrected. CAN 1 has been disposed. I stand corrected. CAN 1 has been
Yes,
disposed.
it has been disposed of. It is disposed of.
Now, I am at the receiving end, my lord, because an order of status quo has been passed by the honorable division bench, and that has been extended.
No, we will dispose of the appeal. The paper book কোথায়? আদিত্য তাহলে একটা কাজ করি, in the meantime আমি এটা করে নিই। Mr. Ghosh is there. Let us pass over the matter for 10 minutes only. Just wait.
whether LCR has come or not.
Yes, it has come.
That is also.
You wait. Yes, sir. Are you now okay? Please come. দেখি এটা কোথায় গেল অনেক একটা item number 18 এখানে yes
certain queries that fell from your lordship on now. This is Miller the order against allowing the counterclaim
Hmm.
of the defendant, where Miller examination of plaintiff was done,
Hmm.
and examination in chief of the defendant was filed. Kindly take my application as a only a few Miller portions. Kindly take my petition. Paragraph 6.
Paragraph 6. Yes.
After narrating what has happened,
Hmm.
the earlier order of rejecting the counterclaim, that is A, I have placed that. Paragraph.
Hmm.
Thereafter, hearing of the associate should commence and the plaintiff petitioner has completed witness.
Hmm.
And the defendant opposite party only files examination on affidavit.
Hmm.
So, the lordship is well aware, under order 6/17, as amended in 2002,
Hmm.
when the trial has commenced,
Hmm.
no amendment should be granted except in extraordinary circumstances.
Hmm.
Now, so far as the first order, which dismiss the application, and that is my ground, kindly take me to the ground one in my petition. For that, the learned judge of the court below, page
Hmm.
11.
Hmm.
For that, the learned judge of the court below acted illegally and with material irregularity in allowing the defendant opposite party to prefer counterclaim
Hmm.
after completion of examination of witness of the petition. Specific ground taken. Apart from that, on merit, whether Benami transaction act is valid or not. But this is the jurisdictional error. I shall rely on a discernment judgment of this honorable.
Yes.
Now kindly come.
Who is representing the opposite party?
to
Someone, the other day, someone was there.
Someone appear. Kindly give me. I have been distant of course, that is not.
Vikas Kumar Chattopadhyay.
Yes. I don't want to meet this party. I can
Then-
point out to your lordship, come up. This is the.
In the meantime, if you can request your advocate on record to notify the date, I am fixing a date for hearing. Let's
Yes,
try
yes.
to get the
Yes.
matter heard
I
in
always
presence
prefer
of both.
I
both.
don't like expert here.
Yes, yes. Hey, Madam Ashwin,
Monday, not tomorrow.
not tomorrow. No, you suggested it. Should it be on 31st of July?
31st of July, Monday. Further notice here? I think that.
You just write a letter to
Yes.
the lawyer concerned indicating the date. That will serve your purpose.
Once we got the examination has started, the cross examination has been done.
Then this counterclaim application was allowed.
Except in few, rarest of the rare cases, that Justice Sanjeev Banerjee's division bench has self-analyzed all the judgments of the Supreme Court and come to the conclusion. A reference was made to the larger bench.
Okay. Very well. You come back on 31st. Heard Mr. Malay Ghosh, senior counsel for the petition. None is, opposite party is not represented. Stop. The petitioner is requested to notify the learned counsel representing the opposite party, indicating that the matter shall be taken up for hearing on 31st of July. Okay. Listed on 31st of July.
I tender my apology. I should be
No, no, don't.
more physically fit. Starting from building number 1 to 3.
It's really difficult. I hope it's not raining outside.
Not this time.
31 July. কি বলছে রিসিভ হয়নি আসছে বলুন কি হয়নি সেখানে বলতে বলুন পরেরটা ডাক হ্যাঁ
Should I beg
26.
to appear on behalf of the appellant?
Yes,
I am appealing for the respondent.
then
In this matter, my lord, I have taken out an application for vacating the interim order on the ground that while the appeal was admitted, stay in connection with a separate suit which is not involved in this second appeal proceeding has been granted. Therefore, my application for vacating was fixed for hearing.
fixed for hearing. And
Along
what
with
about the appeal?
My
My lord,
lord,
the appeal is pending, my lord. The
my lord, on the last occasion. there was a
appeal was
direction to the
admitted and
lordship
they got an interim
report.
order. Report. Lower court record. पेपर बुक फाइल का डायरेक्शन चाहिए पेपर बुक ना एडमिशन समय पेपर बुक का डायरेक्शन होता So if your lordship may kindly look to the order of admission, usually while the second appeals are admitted, there are directions for filing paper book.
এই আদিত্য সেকেন্ড অ্যাপিল ডাকুন তো
দেখুন তো
এটা কবে নেমেছে রেকর্ড 28 জুন আমি ডাইরেকশন দিয়েছি মাত্র 14 জুলাই এটা পাঠিয়েছে
আছে admission।
ডিস্ট্রিক্ট ঝাউড়াকে দেখে জিজ্ঞেস করুন কি ব্যাপার
Milord, there has been, while the second appeal was admitted, your lordship knows, Milord, the second appeal admission is a matter in between appellant and the court. Usually when the court admits it, there are directions for calling for the records.
The records were called for.
I
your
have been
lordship.
informed, Milord, that the records possibly has not arrived before this court. That relates to hearing of the appeal, second appeal. As such, the proceedings, the LCR of the concerned case is required to be brought.
আমাদের কাছে দেরি হয়েছে
If your lordship may kindly take my
My lord, there
application.
are two applications. One is my application stay of the suit, second suit, your lordship, of which I am enjoying an interim order as on date. He has filed an application for vacating of the order. Both the applications were fixed today for hearing, your lordship.
Any one application your lordship can take up, Milord. The fate
Can-
of the hearing is both same.
Same.
Can
four-
number 4 of 2022. Can number 4 of 2022. If your lordship may kindly look to can number 4. Your lordship will find, Milord, the order of admission annexed there with page 7.
Hmm.
Now, Milord, page 7, your lordship will find the appeal was admitted below April 5, 2022. First part is, Milord, delay, not concern, Milord. The appeal has come up for admission. The appellants are not represented, but however, on consideration of materials on record, the judgment of both the court below we direct that this appeal will be heard on substantial question of law. It appears from the order that the appellant was not there, but the court
My lord,
has-
I was represented, your lordship.
But
My name
anyway,
has been
Mila,
recorded as-
but anyway,
No, it was a-
on this point, the appeal has been admitted. Whether the learned judge in the appellate court substantially erred in law in interpreting Section 3A of West Bengal Land Reforms Act 1955 and failing to consider that the right and interest of the tenant and under tenant under Non-Agricultural Tenancy Act vested in the state free from all encumbrances. Now, my lord, the appellant owes a duty to file paper book usually while the appeal is admitted. But I find there is no direction for filing of paper book and there was direction for calling for record. My learned friend says, my lord, that this has not arrived. Now, why this application has been taken out, your lordship may kindly look to paragraph 1. The suit originates from, my lord, title suit
If your lordship
Have
may
you filed
kindly
your
look to
objection?
paragraph 3,
Have you filed your objection, opposition to
Yes,
the
yes.
petition?
opposition they have. filed.
Opposition has been filed.
Now, my
Hmm.
lord, paragraph 3 of my application, your lordship will find this second appeal arises out of a suit 33 of 2010.
Hmm.
The suit filed by my client was dismissed.
Hmm.
Thereafter, my client preferred a first appeal.
Hmm.
The order of dismissal of suit has been set aside,
Hmm.
and the suit has been directed de novo to be tried by the learned trial judge.
Hmm.
These all are in connection of title suit number 33 of 2010. The second appeal arises out of 33 of 10. There has been appeal, and consequent thereto, my lord, this second appeal. Fourth, paragraph 3. Our application, number 4. May I just, my lord, read? It is significant to state here that the instant appeal arises out of the impugned judgment and decree dated 25th August 2017, passed by the learned Additional District Judge Fast Track Court Howrah, and the said appeal arises out of title suit number 33 of 2010, filed by the opposite parties plaintiff in the Court of Learned Civil Judge, Junior Division, First Court Howrah, renumbered as title suit number such and such. Accordingly, the instant second appeal arises out of title suit number 33 of 2010, renumbered as title suit number such. It would appear from the judgment and decree passed by the learned trial judge that the learned trial judge by judgment and decree dated 31st March 2016 has inter alia been pleased to dismiss the said suit on contest against the order of dismissal of suit. It is the plaintiff who preferred appeal title appeal number 56 of 2016, challenging the order of dismissal of suit passed by the learned trial judge and by the impugned judgment and decree dated 25th August 2017. The learned judge in the first appellate court, being Additional District Judge Fast Track Court 2 Howrah, has inter alia been pleased to set aside the judgment and decree passed by the learned trial judge, dismissing the suit.
Coordinate bench on 19th of May passed this order of stay of all further proceedings of title suit 774 of 28.
774.
Now you want to get this order
Vacated.
vacated.
Yes, because, my lord, this title suit number 774 is not concerned in this instant second appeal. Kindly have a look to their own application. Their own application and the impugned judgment and decree. This title suit number 774 is based, filed by my client plaintiff in view of the fact that the order of dismissal of suit has been set aside in appeal and the matter has been directed de novo hearing.
Now, what is the subject matter of that suit?
The subject, if your lordship may kindly look to the memorandum of appeal filed by them.
No. It's a suit for recovery of possession.
Yes.
Declaration of tenancy and recovery of possession.
Your lordship will get the plain copy of plain.
Declaration of tenancy and recovery of possession.
774 of 2000.
Rounds counter.
774 of 2018, page 6, is the suit filed by my client. This suit I filed because, my lord, the earlier suit of dismissal, the earlier suit in which
Identical suit property.
Suit property
Same
is
suit property.
Fine.
Suit property.
What is the correlation between your client and the client represented by Ms. Datta?
May I just? The earlier suit filed by my client was dismissed by trial judge.
Who was your client in respect of the suit
Plaintiff.
property?
Plaintiff is my client, and my suit was
Plaintiff, owner, landlord, or
owner of the
yes.
property.
You were representing the owner.
Owner of the property, plaintiff. In both suits. My client is plaintiff in
Yes.
both suits.
What was the subject matter of 33?
The subject matter was, my lord, that he sought for declaration that they have no right in respect of the suit property, and we have consequently to declare that we are owner of the property. They took a plea that the property is a thika property, and on this plea being taken, the suit filed by my client was dismissed. The earlier suit filed by my client was dismissed.
Earlier suit was filed seeking declaration of title.
Title by my client.
Declaration
Yes.
of his title and a declaration that I am a tenant.
Tenant.
Yes,
That suit was dismissed.
dismissed.
Fine.
Thereafter, my client preferred appeal. The
Remanded.
appellate court remanded.
No, your
Therefore,
lordship. The
That-
appeal court did not remand. The appeal court judgment's order was at page 9 of the page 9, your lordship. It says the title appeal being such and such be and the same is allowed on contest without any cost. The judgment dated such and such passed by learned civil judge junior division, first court Howrah in connection with title suit number 33 of 2010 is hereby set aside. A copy of the order along with LCR be sent down. That is the order, your lordship. That
the
is
order of dismissal was set aside.
It
Your
was set
lordship,
aside without
your lordship
passing-
may kindly look to the judgment
Yes.
itself. But the order of dismissal of suit
It did
was
not
set.
send it for remand, your lordship. It did not say what is the
So
relief
what
that
does
is
it
being
convey
granted,
actually?
my lord.
The dismissal goes.
The dismissal goes.
Then what remains?
Nothing remains, your lordship.
Now-
He ought to have given him a decree stating whatever he has sought for. The relief he sought for. has
You have
not been-
accepted that judgment.
Yes,
He has accepted the judgment. Against that judgment, I am before your lordship in the second appeal.
Fine.
now, my lord, the dismissal order was set aside. Now, my lord, the suit stands de novo to be tried because nothing gets decided. Once the dismissal of suit is set aside, that means all issues are yet to be decided between the
Now, kindly
parties.
take-
So implied remand.
Implied that the issue in earlier suit was not decided. In effect,
However,
now-
in their plain,
now my client
Now pending
filed
that suit,
separate suit.
pending that suit, awaiting declaration as to your status as owner, you have
Filed
taken
a suit for eviction
eviction.
because that decree
Then why-
remains.
Then why it should be recalled, order of stay?
The decree passed by the appellate court remains.
Fine.
It has not been set aside. Now, what I am on before
Your
lordship,
status is yet to be decided. In the meantime, you have filed a suit for her eviction.
now, my lord,
It was stayed by the honorable coordinate bench. Why it should be interfered with?
the suit which has been stayed is a separate suit. It is not percolating or arising out of this suit.
Impliedly, now again impliedly under section 10.
Now, my lord, if by implication, your lordship knows, my lord, if by implication I do not take the appellate court also, at best it will reveal that the dismissal order of suit is not there. Dismissal order of suit is not there, and the issue are yet to be decided. Now, a licensee in the property, because of this stay or because challenging this order,
Licensee
will be
under whom?
entitled
Licensee under whom?
under me, will be
Yeah.
entitled to reap the benefit without
My-
making any payment.
Mr. Gupta, your status is yet to be declared.
My lord.
My lord, the status of the other side is clear from the defense taken by them. The point on which it has been admitted is not his status. It
I
is
shall-
on a point of law.
I shall
What-
take up all your applications and application filed by the appellant together with the appeal. LCR has not come.
One thing what I would
Yes,
say, my
yes.
lord, one thing subject.
Let the
one-
interim order continue.
My lord, one thing, the difficulty which will come in that while this 774 we have filed, this is at the stage of filing written statement. My learned friend has possibly not yet filed written statement. Immediately because of this stay, they are preventing. In effect, the court is prevented from proceeding with the
Yes.
matter.
That is the
Now,
order.
one thing your lordship may modify to this extent that since the appeal is required to be heard, and this is something which is involved in that proceeding also, therefore let the impugned judgment and decree, final judgment and decree in title suit be not passed for 1 month or 2
Very good.
months, but there should be that suit or stay of this may not endures a benefit to him totally, and stay of a separate suit under section 100 cannot be granted. Your lordship may recollect, my lord, that Videocon's judgment, and this is a step in a suit. Second appeal, section 100 is a step in a concerned suit. The power of the court is limited or restricted to the suit itself.
Very well. I shall lend my ear to you on 10th of August. In the meantime, let us try to bring the LCR. If it comes, I will
I
hear
do
you.
not know whether they have deposited for her.
please.
So let them take steps so that it can be brought and
No. Have you not deposited?
Yes, your lordship.
she has
No,
deposited.
only difficulty is on my side.
No,
The record did not go down to the department, so they couldn't comply with the direction. That is the whole difficulty.
No, my lord, let the
So I
department,
can,
let the
yes.
department ensure that it comes.
yes,
And-
on 10th of August,
My-
I shall take up. Madam.
Now, the jurisdiction of second appeal is restricted to the proceeding alone. If there are other proceeding and they intend to get a stay, in that case, they need to
didn't-
file an application.
Why didn't you take out an
Another
application under section 10
which
before the
can
trial?
be done,
In the
but
trial
this can't be done in section 100.
In trial court, your lordship, since the suit was filed on the strength of the judgment and decree under
Fine.
challenge, your lordship. in-
Section 10 is to
And-
be taken out before the learned trial
Yes.
court first.
My lord.
And their court gets jurisdiction to stay. It can't be under section
Once
100.
an order was passed by this court, there was no necessity.
They want to enjoy.
My lord wishes to vacate the
Now
order.
the basic question is raised by Mr.
Yes,
Gupta.
yes.
My lord,
Can
okay.
such order be passed in second appeal?
At best, it gives him a right to urge it in court below.
If
if
the,
it-
if
she
this
doesn't get-
order under which he is, since this decree cannot be executed, the second suit that he has filed is his way of executing the decree. Your
No,
lordship.
Oh,
My
I
lord,
must
kindly-
succeed in that suit.
there has to have a decree first.
First,
Yes, he does not have a degree,
it's-
but in his plaint in the second suit, he says that since the suit was dismissed, dismissal of the suit has been set aside in the appeal. He does not say anything about the second appeal. Since it has been set aside, he files a fresh
Mr.
suit.
Gupta has raised a very fundamental.
I understand, your lordship. Under section 10,
Yes. Heard Mr. Gupta learned counsel for the respondent,
respondent decree.
decree holder. Since the LCR has not arrived as yet,
Paper book.
the matter is adjourned to appear on 10th of August 2023. Department is directed to take necessary step for compliance of the order date 28th June 2023. Applications being, what is your application pending?
my stay application, your lordship.
There is an interim order of,
Yes,
Till
the-
today, your lordship.
Till today, the interim order was granted
Till the, your lordship.
with a rider that applications both would be heard. That was the direction of earlier bench also.
then what's the point of filing this separate can? While disposing of can 4, we can take this, we can pass the required order if we don't extend the stay order.
Let this interim order be
Okay.
extended till that, because my lord, they will be getting a benefit and my suit
No,
gets arrested.
I'm
All
extending.
We will try not that the entire appeal is heard and
My lord,
disposed of.
may a informal paper book be filed? in
Yes.
the-
It was
Second,
compliance of the order. Appellant is directed to prepare requisite number of informal paper books in the meantime. On the adjourned date, both the appeal and applications pending shall be taken up together for hearing. Interim order shall endure till that date.
grateful.
Grateful,
Cannot
your
acclaim? Cannot acclaim? LCR আসেনি? LCR আপনি কি পেয়েছেন LCR? Yes.
Sevati.
Where is both Banerjees? Yes.
Sevati ka dekho.
My lord, just Mr. Ghosh, just a minute. The difficulty is department is yet to examine the LCR. So I am adjourning the matter. কতদিন লাগবে দিদি? কত সময় লাগবে আপনাদের করতে? হ্যাঁ আমি দেবে আজকেই দেবে আবার দুদিন কিছু নেই আপনার দুদিন তো ভেরি ওয়েল এই ওই অ্যাপিলটা যেটা ওরা আছেন না আইটেম নাম্বার কত Mr. Haradhan Banerjee and Mr. Ritendra Banerjee learning council.
In the next week, I will not be available out of a station. And Lord, another week, Lord, I shall require to examine the record.
You need 1 week. Department will take 2 days.
No.
You should take only 1 day.
You will, 1 day. not-
Suggest a date. Don't give so many.
Oh, yes.
Suggest a date.
Tomorrow.
Ritendra Banerjee, learned counsels representing the parties are present. It is reported that LCR is yet to be examined by the department. The matter is adjourned to appear
On 9th of August.
9th of August.
Would it be
Tenth of
subject to your lordships?
Urgent to appear on 10th of August 2023. ঠিক আছে এর মধ্যে একটু রেডি করে
Lord, the interim order.
Would it be my lord's kind?
আগেরটা হ্যাঁ করে দিন না সেই যা করে করুন ঠিক আছে yes
Lord, the interim order be extended till 15th of August.
why
Because 10th is the date fixed.
you have enjoyed enough
No.
interim order shall endure till that day it will be till the date of hearing
Yes. Lord, we want to do the case.
Would it be my lord's kind sanction to grant us liberty to inspect the lower court records?
go and
Or
but
to record one
but
line?
the record will be going down to the
Kindly
department
records that, my lord. Otherwise, my lord, sometimes there are difficulties, my lord, practical difficulties. Kindly records that will be fine.
yes liberty is given to learned counsels to examine the lower court record
করে নিয়ে আমরা
For both the parties.
after the examination by the department is over. Thank you. Hi, Dakun. Yes, what's your matter?
The next matter.
For the appellant, my lord.
My lord, in this matter, by your lordship's last order, your lordship had directed the registrar of the small causes court to give us.
Exhibits.
Yes, my lord, now we have got it yesterday, on 18th of July. That's why I got the original certified copy. Your lordship sees the endorsement. My lord,
Suggest a date.
my lord, within 28th, we will prepare the additional paper book, informal additional paper book and supply. Kindly fixes it on 2nd of August.
My lord, kindly fix it on the
Item
second week of
27.
the August.
No, not second week.
2nd of
My
August.
lord, we have to go through the supplementary paper book.
But these are all exhibits in the, I am not giving nothing new.
You will be having enough time.
Yes, sir. By 26th, 27th, I will be giving them.
When your adversary will say something, as a matter of course, you have to oppose.
Yes,
Take down. Mr. Ghosh, learned counsel for the appellant submits that only on 18th of July, the appellant has received the certified copy of the exhibits required for the purpose of preparation of supplementary paper book.
Well, not the appellant.
You are
I'm
the
the respondent.
respondent. Oh, I'm sorry.
Respondent plaintiff.
You are the appellant.
Yeah.
Okay.
Very interesting point.
Huh.
7172.
করেছেন ওটা? Under such circumstances, matter is adjourned to appear on 2nd of August 2023 under the heading hearing.
My lords.
In the meantime, parties are to take required step. This direction is peremptory.
Yes, yes, shall be done. We have got this.
Mr. Mukherjee will lead you.
Yes.
Just let him know. There will be no adjournment on that.
Absolutely. But I can tell you, assure your lordship, whichever way it goes, but it will be a very, very interesting point.
Go.
My lord, here also it's my second appeal.
Hmm.
My lord, pursuant to your lordship's last direction, we had served the other side. My lord, affidavit of service is kindly takes the affidavit of service. My lord, kindly allow me to file the affidavit of service in this case.
Who is representing the respondent
My lord, we have served directly on the parties.
on the parties?
That was the order. Because nobody appeared, my lord, to represent them, even on earlier occasions. My lord, we had, my lord, served directly to the parties, and each and every, my lord, letter has been delivered.
Appeal is otherwise ready.
Absolutely ready, my lord, short point, but I'll just indicate what the point is. My lord, the plaintiff filed a suit for partition against the defendants, saying that the property of his grandfather, by dint of will and otherwise by inheritance from his parents, has come to him and the other defendants who are Kaka and Pishis. So he filed the suit, declaring that he has 60% in the property and the defendants have 40%. Well, a written statement filed by the defendants, nobody challenging the fact that the grandfather did not own the house. No point taken. Only point taken is that the will is not there, probate does not confer title, so on and so forth. Milord, the learned trial judge, the court of first instance, holds on his own, without taking that, nobody taking that point, that because the plaintiff has not been able to prove any documentary evidence to prove the title of the property of his grandfather, he does not have title and nobody has title. Hence, no question relating to the suit can be decided in this partition suit. The appeal court, without appreciating the grounds of appeal, my lord, similarly toes the line. My lord, all I am saying is, my lord, section 58 of the Evidence Act is clear. If nobody, facts which are admitted need not be proved. My lord, I have got judgments of this court, division bench.
You come to order 10, order 15, everything. When parties are not at issue, judgment should be
Absolutely.
pronounced
cannot-
then and there.
Yes, they need not be go through trial at all. Now, my
While
lord,
sitting in division bench with Justice Sen,
yes.
in one matter, Mr. Hirok Mitra was representing, and we have pronounced the
First,
judgment
my lord,
on
I
that.
shall find that out also.
Yes.
The division bench to now, Kolkata?
Order 10 is clear enough. Unfortunately, first hearing is not being conducted before the learned trial court. That is the whole difficulty. It
And my
says
lord,
where
and my lord, section 103 of the code is also
Yes.
very clear. Your lordship's my lord can not only correct that,
Yes.
but also pass a decree for partition. Kindly see, my lord, the order of the trial court, my lord, which is, my lord, page, my lord, 1 to 16. My lord, kindly see page 12, page 2 onwards. My lord, during his one Vibhuti Bhushan Bose, as a grandfather, was the absolute owner of the suit property. He died on 71. During his lifetime, by executing a will on 19 June 71, during his lifetime, by executing a will on 57, he bequeathed Umarani Bose, that is his wife, as absolute owner in respect to the suit property. But if Umarani Bose did not transfer the said property, then 50% will go in favor of the plaintiff, that is the Nati, and another 50% will go in favor of Bimal Kamti Bose, since deceased, Nivarani Bose, since deceased, respectively the father and mother of the plaintiff, and the defendants in this suit after the death of the said Vibhuti Bhushan and Umarani. Defendants are the other Kaka and Pishis. Lord, kindly see, I'm just taking your lordship to the relevant provision. Lord, kindly straight away, my lord, come to page 4, third paragraph. Page 4, third paragraph. Short facts of the defense case according to the defendant number 1 is as such. Vibhuti Bhushan Bose was the owner of the suit property. Defendant number 1 admits Vibhuti Bhushan Bose was the owner of the suit property. This defendant is not aware of the alleged will. That's a different point. He denies that 60% share of the plaintiff in the suit property. This defendant, along with other defendants, have been living in the suit property where the plaintiff is not living. Plaintiff is not entitled to get 60%. This defendant states that the property should be partitioned in equal shares. That's on merits. Then, my lord, kindly come to the next page, page 5. Run through of the defense case according to the defendant numbers 2 to 4. They filed different written statement 1 and 2 to 4.
Said Vibhuti Bhushan Bose never executed any will as claimed by the plaintiff, and as such question of obtaining any probate. Plaintiff and defendant as a joint owners. Absolutely false in the picture. So nobody, none of the defendants, my lord. And all the construction was made by original owner Vibhuti Bhushan
That
Bose.
is a difference.
Yes. Now kindly come to the exhibits, page 6. Documents, copy of the probate of the will of Vibhuti Bhushan, certificate of Vibhuti Bhushan Bose. Then, my lord, kindly turns over page 7, corporation tax receipts showing that the properties was in the name of Vibhuti Bhushan Bose. Corporation tax receipts, exhibit 15, also showing Vibhuti Bhushan Bose. Now, my lord, kindly see.
Anyway, we'll decide it.
Yes.
Just if possible. Oh, LCR to issue.
LCR has come, my lord. LCR has come.
You suggested it, madam. Affidavit of service is taken on record. Despite service, none is appearing on behalf of the respondent. Mr. Rupok Ghosh. Heard Mr. Rupok Ghosh, learned counsel for the appellant. Let the matter be listed.
As soon as possible. But next week, any day, my lord, I shall come back. Your lordship has got the matter.
No. Then you come on 31st.
31st.
26, 27, 28, I'm practically overburdened.
My lord, I'll come on 31st. My lord. Is it your lordship's pleasure we give them one more notice?
Your uncle, it's better because you know, again they will come and say,
My lord, it's better recalling this,
Yes.
that, my lord.
একটা কাজ করুন তো। In the meantime, appellant is directed to serve a fresh upon the respondents.
And that in their absence, my lord, the matter will be
Yes.
taken up for him. But
Under
31st, your lordship is putting
31st.
for yes. Lordship, নিজের একটা judgment থাকলে
No, that's yes, almost similar situation. Father, no document was there, but there was no denial. Everyone is saying father is the owner.
Then, my lord, I will get that. That should be the end of the matter.
So we
That-
said, why not order 10? Why not order 15? Why you take? Why did you? What prompted you to take the matter to the stage of hearing?
Yes. Any event that went, my lord, now judge records also section 58, but does not give credence to it. Allowed, lordships have allowed in the division, but that's what my lord was pleased enough to indicate.
There is no
to us.
point, you know, order 10, we don't follow. Order 15 is clear. If there is parties are not at issue, it should
Then why
be
should the court take
disposed
it?
of.
Why should the court take it upon himself?
That is order 15 rule
My
1
lord,
also.
I shall.
Anyway,
I shall get hold of the judgment, my lord. The single bench judgment of our High Court, the other also relies on section 58 and says the same thing. If the
No,
parties
we-
are not taking that part, why should the court
we
take
were
that?
on order 10, order 15 rule 1 in addition to section 58. 58 was there
Yes.
also.
So, but that will be even more helpful, my lord. I shall.
That I don't know, but
No, no. Since
It
your
is-
lordship is saying that
there was no reason to take the
matter to trial,
Yes.
absolutely.
Anyway, you come back on
My lord.
31st. Aditya, next one.
Your lordship before the
29.
opposite party.
Yes.
But
There was the last occasion, my lord has directed me to seek instruction and to the conviction
Lordship
of
may
the
very kind,
status of the execution case. The
Hmm.
execution is still pending, your lordship.
Still pending.
my lord may very kindly recollect, my lord. I am for the defendant judgment letter petition before my lord, my lord.
It's a partition. suit.
Partition suit is over, my lord. By expertise, by decree was there, both in preliminary and in
All
final.
you want.
And thereafter, my lord, I never filed any.
He
No.
chose to
So
not.
you have
I-
accepted everything.
I accident. Only thing, my lord, the commissioners did not give any notice of,
Your lordship,
and
all-
that, and my lord, that will.
On that issue, your lordship kindly come to LAG.
No, sir.
Yes, yes. That is the
Now-
only thing, my lord. I
now-
I cannot now agitate
Since the final decree has been passed, There
Carry
is
over.
no room to,
No, I am not claiming that also.
yes,
Ah.
only thing you
Only-
can ask for is a demarcation.
Fresh
and
demarcation,
Your
best.
Lordship,
Only
Not
thing.
fresh demarcation, only delivery of possession, pursuant
Delivery
to
of possession.
final.
Your Lordship,
By the commissioner once again, my lord, because
Your
that
Lordship, kindly come to pay, allege impugned order at page number 3, para 8. The
Para 8
learned
is
judge
there.
below has categorically stated that
No,
the
no,
notice was
I will
served
also
upon-
place, I will also place para 8, my lord.
Don't reopen that. Since final decree has been passed, either he has to challenge the final decree in
I
appeal,
could not.
or he is only asking for the delivery of possession in terms of final decree. What's the harm?
Your Lordship, the issue has already been settled.
How can it?
Partition, final decree in a suit for partition has taken place, right? Now the property allotted to this gentleman, the petitioner, that is to be delivered to him. That is the purpose of execution.
Your
Keep
Lordship,
Only direction he is seeking is that his allotment may be delivered to him in terms of partition degree. What's the harm?
he will again create nuisance in dual delivery.
If he creates any nuisance, it will give birth to another cause of action. You go file
Lordship,
suit,
my client
civil,
is in
criminal. Under the law, can I restrain anyone from taking?
no.
So,
But Your Lordship, my client is
That's
an
my only one.
paralyzed, aged 80 and above old.
I
person.
don't really find
That
any
is the
sense.
only relief I can get, my lord. From your-
He has accepted the final degree.
My lord.
Only thing is that allot my share. Whatever allotment,
Allotment has already.
just deliver the possession.
My lord, kindly
Possession, yes.
specify that particular portion. in
That
my
is
lord-
what he has been saying on the other day also.
By the commissioner.
Mr. Mukhopadhyay says the same thing.
Yes.
Yes.
Dispose of.
Heard Miss Mukherjee, learned counsel for the OP, who informs the court that title execution.
Execution case is pending, Your Lordship.
What is the number? Could you please tell me the number?
Execution.
Is there, my lord, এটাই তো যেটা ছিল আগে তো।
Is disposed of with the direction upon the learned trial court to instruct the learned advocate commissioner
Or partition commission.
to, yes, to deliver the possession allotted to the petitioner, defend number, you are,
I am not a judgment data, my lord. I'm correct. Okay.
to the petitioner slash defendant, whatever, slash judgment debtor. What is the number?
Your Lordship, probably number. Up.
না বডিটা দিইনি দেখি খালি করে পিটিশনের খালি লিখেছি তো রংলি ড্রাফটেড এটা উচিত না এখানে দেখি অ্যাপেলেন্ট অ্যাপেলেন্ট সুপরমাজি আমরা যে পার্টি আছে কি ছিল kindly bear with me.
You don't know. কি লিখলাম?
কিন্তু বুঝতে পারবো না।
The partition, learned commissioner, who has been given the writ, to deliver the property writ, WRIT, writ of possession, to deliver the property allotted to Sri Sukumar Maji
And others, my lord. Sukumar Maji, Nondo Maji,
So all the defendants
yes, all the defendants,
uh,
all the defendants,
allotted to deliver the property allotted to all the
defendant.
defendants judgment debtors in the final decree, by in terms of final decree.
Into the final decree. And only one thing, upon giving notice, fresh notice,
He's present, your lordship.
upon giving fresh notice, that will no harm by
Again,
anybody.
an issue will be created for serving of
And notice to be given, my lord.
My learned
What
friend
for the
is
purpose of,
present, your lordship.
You are not supposed to give any notice. It is the commissioner who will notify, look, I am
Yes.
going to give the delivery of possession on so and
deeply
so.
observed.
It is expected that learned partition commissioner shall notify the parties
Yes,
before executing the writ of possession in terms of the order of this court. Stop. This revisional application is thus disposed of. Copy of the order be, parties are directed to, parties are at liberty to act upon the,
server copy,
কি বলেন ওটাকে,
server copy.
server copy duly downloaded. আর তারপরে urgent photostat copy, certified copy, whatever লিখে দিলাম 2 lines.
Oblige, your
ঠিক আছে।
lordship.
Deeply,
না, sorry, not good. Sorry.
deeply observed,
আগের order এ লেখা আছে। Oblige, your lordship.
disposed of.
Thank you. Then this is Sukumar. 30. Second.
Respondents in this.
Yes.
Last application on 12th this month, my lord was pleased to vacate the interim order
Yes.
and directed the matter will appear as for orders today. Because not the appellant, sole appellant died and the tried to serve successive attempt to serve upon the heirs of the appellant was filed the substitution application, but thereafter they are not appearing, and that's why
This is a suit for eviction, no?
suit for eviction.
They are neither they are appearing nor they are paying the occupational
Occupation
charges.
charge.
ঠিক আছে।
And I repeatedly tried to serve, but refused. And the learned advocate expressly says that he has
He has
returned
no
the,
instruction.
that notice is also annexed with the earlier
Yes.
affidavit of service.
Madam, Mr. Chakraborty, learned counsel, is representing the respondents. None is appearing on behalf of the appellant. Let the appeal be dismissed for default with cost of rupees 5,000. Per second.
Pursuing this, I think for last 4 years, they are not.
Why I fail to understand why these matters are pending.
Not repeatedly, it was enlisted, then gone out of list.
No, you people love to take adjournment and you keep the matters.
Never. I took every
No,
opportunity.
I'm-
Unfortunately, it was not refused.
There are trivial issues pending for years together. Anyway, then. You were only interested in interim orders. Once it is given, bus. Yes, দিন এবার দিন আমি ওগুলো ডিসপোজ অফ করি ওগুলো কি সেকেন্ড অ্যাপিল আচ্ছা ঠিক আছে ছেড়ে দিন আপনি রিভিশনে চলে আসুন Then এগুলো তো সেকেন্ড কল তো বাস দিয়ে দিন আমি অর্ডার করে দিই। ডিভিশন বেঞ্চের অর্ডার কেন? বাই ডিভিশন কন্টেম্পট মূল পিটিশনটা কোথায় আসেনি, 16 সালের পরে আসছে। ম্যাডাম, since the matter is appearing 33 after appearing after 7 years, instead of disposing of the same, I am inclined to adjourn the matter suo motu. Let the matter be listed on 2nd of August under the heading for order. দেখি then এও তাই। Matter is appearing after 4 years. List on 1st of August under the heading for orders. Then এও কি তাই? Same order, madam. Same. Hmm. First, dispose of this. Hmm. Same order. সবই বলে এরকম নাকি? Do you have any matter? No.
Now 55.
55 after
Already-
lunch.
Yesterday I also mentioned this matter, fixed in first week of the August.
Okay. ওই 55টা একটু নোট রাখবেন তো। 2nd of August.
2nd of August, yes.
আমি তো নোট রাখুন, আমি
Item
ফর্মাল
number
অর্ডার
55.
করব। সেম অর্ডার ম্যাডাম। আইটেম নাম্বার 55 টা একটুখানি বলে দিন, লিখে নেবেন। Mr. Dash, learned counsel representing the applicant, is seeking an accommodation. List the matter on 2nd of August 2023. Yes, দেখো পরে বলে যাবো।
Number 40, my lord, Mr. Varun Kumar Das is appearing for the applicant, my lord. My lord, it's a old matter, my lord. Kindly make it 2 weeks adjournment. Instruction is required.
Why this routine prayer 2 weeks? Why not 3 weeks, 4 weeks, 8 weeks?
My lord, matters
Why
of
2 weeks all the
2011.
time?
CO is filed in 2011.
Hmm?
The application filed in 2011, my lord.
Do you have Vakalat number? No. What is your good name?
I am Ziaul Haq. I am not in this matter, my lord.
You are not in this
Mr.
matter then?
Mr. Das is advocate and representing Mr. Nivarun Kumar Das. He instructed me to pay for the adjournment,
2nd of August.
my lord.
No, no. Okay. 2nd of August.
2nd of August.
My lord, item number 41, my lord. It is written in our old diaries. Kindly, my lord, let me check the file as because I don't know, my lord, whether it is.
You
for
check the
whom we
file.
are appearing, my lord.
Hmm?
For whom we are appearing, that also.
That also is not known to you. 2nd of August.
Deeply obliged.
You just go through whatever you
My
want.
lord, deeply obliged.
Like,
আমার নামটা রেকর্ড করবেন তখন আপনি চাই না কার হয়ে আমি আছি
ওই সেম অর্ডার করে দিন।
ডিপলি obliged.
এখানে তো কেউই নেই, এমনি Under the heading for orders. পরের adjourn date আমি dispose of করব। হুম। সেম ম্যাডাম আজকে সবাই আছে দেখি সেকেন্ড অবশ্যই ভাগ করে করে দিচ্ছে প্রথম আসছে আমার কাছে হ্যাঁ আইডেন্টিক্যাল সেম অর্ডার দেখে নিন যদি আমার কাছে এটা মেইডেন প্রোডাকশন হয় অ্যাডজন করে দেবো হ্যাঁ এই প্রথম হ্যাঁ তো 2nd অগস্ট হুম 2nd অগস্ট হ্যাঁ আমার কাছে তো প্রথম এসছে আমি একবার অ্যাডজন করে অন দি অ্যাডজন ডেট করবো 54 অব্দি আছে 54 না সরি 50 অব্দি আছে ডেকে দিন বা না দিন ওই সবই 2nd অগস্ট অব্দি থাকবে 44 অব্দি হলো তাই তো আপনি 50 অব্দি একই অর্ডার রিপ্লাই তারপরে এসে সেকেন্ড
I beg to appear for the appellant in this matter.
I appear for the respondent number 11 along with my friend.
In this matter, we have filed one application for additional evidence, not order for rule 27. It is appearing in the list. May I just give the brief background facts? This is not arising out of a suit for specific performance of a contract.
I'll take my seat.
The appellant before your lordship was the added defendant number 11. Originally, only two defendants were there. The persons who were entered into the agreement with the plaintiffs. Subsequently, we were added. Now, the date of the agreement is 15th of February 1993.
Just a minute. 15th April.
15th of February 1993.
February 1993.
This was between the plaintiff and defendants number 1 and 2 in the suit. They were the only defendants at that point of time. Now from lot 3 onwards up to 11 were subsequently added.
Why?
Because dispute arose, I couldn't get hold of the order 1 rule 10 application, but I am not purchaser of a portion of a property. I have purchased
You are 11.
11. And the others they also claimed ownership over the property. The main dispute is regarding ownership. Our main point on which it is admitted is that the agreement holders who have entered into the agreement, they didn't have title to the property. So they could not have conveyed it.
So you mean to say agreement holder is plaintiff?
Plaintiff is the agreement holder. The
Plaintiff didn't have
the seller, no. The defendant number 1 and
2. They didn't have the title.
The proposed sellers didn't have title to the property. On this point, the appeal has been admitted. Now, I'll give them a chronology of how title has come. Before that, one of the points is that defendant number 11 was never served in the matter. No service. So far as the defendant number 9 and 10 they refused. 5 to 8 substituted serve. Order 5 rule 20 was filed. They were not served by paper publication. But from the order sheet, it doesn't appear that 11 was served at all. So the court has passed the decree without satisfaction that 11 has been served at all.
Okay.
But this is the order sheet. May I just point out two certificate copy of the order sheet. 30th, 16th August. Kindly see 16th August. Yes. Up to 15 months, 2-3 orders. Just kindly see. Number 10 of the service. Lordship will see 15th August. Court recorded that 5 to 8. Up to this
Order 5 rule 20 3 to 8.
Yes, ma'am.
Returned unserved with the remark left as per submission.
3 to 8. 3 to 8. Order 5 rule 20. 9, 10 refused. But 11, there is no whisper about 11. I am the purchaser of the property. Order sheet. Finding regarding service. My junior will find out if there is any subsequent order recording service. I couldn't find. Now, my lord, the facts are like this. Property originally belonged to one Purnendu, admitted. From Purnendu, upon his death, devolved upon legal heirs, wife, Madhavi, Nilangshu, son, and Shamoli, daughter. Up to this also not admitted.
Purnendu, then widow,
Madhavi, Nilangshu, Shamoli.
Nilangshu, Shamoli.
Yes.
So 3.
3. Wife, son, daughter. Now, Lord, the defendant number 1 and 2 agreed to sell on the basis of a sale deed dated 3rd of April 1987, by which the 3 heirs sold to Kailash and Manoj, defendant number 1 and 2. 3rd of April 1987, there was a sale deed. On the basis of this, they claim to have become owner of the property
and they entered into agreement for sale in 1993.
The defendant number 1 and 2 claim to have
Purchased
derived title from
Purchase
these
title
three.
by way of a purchase deed dated 3rd of April 1987.
3rd of April 1986.
I'll place the agreement for sale. This will also appear from the agreement for sale. And the contrary case now not set up by us, we could not appear in the suit or file WS. In the appeal, we have set up a contrary case. The case is that the property belongs to Purnendu admitted. The three legal heirs, Madhavi, Nilangshu, Shamoli admitted. Then, a suit was filed by Shamlan and Hanuman Prasad, who were the lessee under Madhavi, original Purnendu, who was the lessee. Subsequently, property in 2001 have been sold to Shamlan and Hanuman Prasad.
2001.
2001. So the 87 deed comes in the way. I'll explain that also. 2001. It was sold to Shamlal Hanuman Prasad. In the meantime, they were the lessee, they were tendering rent. And it was further the case that the 87 deed, that was the ostensible sale, loan was taken, it was ostensible sale. Upon payment or repayment of the loan, the deed was returned. It was never acted upon, the deed is not a valid deed. On this ground, suit was filed by the Shamlal and Hanuman Prasad. This suit was decreed in a compromise, where everybody was party.
Everybody means
everybody means not the plaintiffs, not the plaintiff.
No,
but
the defendant number 1,
1 and 2 were party.
They were party.
Yes, they were party. Defendant 1, 2 were party. Kailash Manoj and the legal heirs were also parties. Legal heirs of
what is the suit number?
My lord, suit
What
number.
is the suit
That
number?
is suit number 39 of 2002. So the compromise decree was passed in that suit, where it was held that the 87 deed is not a sale deed at all. It was only an ostensible sale for the performance of the loan agreement. That decree was not challenged. That was in 2002. So by virtue of that decree between defendant number 1 and 2 and my vendor, it becomes final, and the 87 deed goes. If the 87 deed goes, then 1 and 2 had no right to enter into a agreement for sale of the property.
Your vendor is
My vendor
Shamlal
is my vendor is Shamlal and Hanuman Prasad.
Hanuman Prasad.
Yes.
Yes.
We have purchased in 2001. No, we have 2001. Shamlal and Hanuman purchased from Madhavi and son and daughter. We purchased in 2006. We purchased in 2006. So this is the factual background. Two contrary cases. Their case is that 87 deed. Our case is this compromise decree and 2001 deed by which Shamlal became owner. Subsequently, we purchased. But this was not put up by way of a written statement. So this is the ground of admission. Apart from that, the point I want to urge at that the agreement was of 15th of February 1993. Suit was filed in 2001. The agreement says that they will within 2 years they will make an inquiry to be satisfied about the title and upon removal of the encumbrances. So the court has construed this as if unless the encumbrance is removed, the time for performance will continue. But I humbly submit that that is not the case. Within 2 years, you have to satisfy about these two, because 2 years is the outer limit. After that, the limitation starts. So that would be 95, and 2 suits were filed by them. By power of attorney was also given by 1 and 2. They filed 2 suits for eviction of the occupiers. Those suits were decreed on 3rd of July 97 and 17th of September 1998. 2 eviction decrees were passed. After that, they filed the suit on 5th of February 2001, first letter by the advocate that kindly perform the agreement. So almost 2.5 years gap. Even after the eviction decree, if they say that is removal of encumbrance, then also there is a gap of 2.5 years. Then they filed the eviction suit, filed a notice, served a notice and filed the suit for specific performance. So my first point is, apart from the point of admission, this is also a question of law. Section 50, Article 54 hits the suit because it should be 2 years from the agreement. And even if they cross the hurdle, that no, since the suits were pending, decree was passed in 98, so limitation will start from there. But there are some line of judgments which say that
The delay in approaching the court, that is also relevant factor because specific performance is a discretionary release. So if
Yes.
it is within 3 years also, but there was a delay, then the delay in performance will also be treated strictly by the court. This is the second line of argument. So, my lord, first point is, my lord, no title. Second point is, my lord, this delay. And the third point is, my lord, in the suit, there is only averment that we were always ready and willing to perform. Because under section 16 amended provision, 16C of the Specific Relief Act, my lord, there has to be pleading, it has to be pleaded and proved. They have said that we are ready and willing to perform. But that was in 1993. Not a single document, no averment, no proof that there was any approach by them from 1993 to 2001 for performance of the contract. First approach, first letter is February 2001. So, if not the limitation clause, the clause stipulating time limit, if it is construed strictly, then they are out. And if it is not construed liberally, then also they get an extension till the second eviction decree on 17th September 98. From 98 to 2001 also there is no communication. So for this period also there is no readiness and willingness. If they say that is the removal of encumbrance period, then also this 2.5 years there is no readiness and willingness. So on this score also, my lord, the court should not have exercised the discretion to grant specific performance. These are the three grounds, my lord, of challenge. Now, my lord, may I show the agreement, because if the first point I succeed, then the other point not.
You don't have to. Aj. Yes. Agreement. देखिए LCR टेस्ट
No, LCR, unfortunately, the LCR has suit was appeal was dismissed for default. Subsequently restored. It has gone back.
It has gone back. Do you have the copy with your application and order for
stay application was filed. It is part of the stay application.
This is your CAN.
Stay application
CAN
4701.
4701.
Here, my lord, it is annexed. If your lordship kindly comes to page 41, my lord. No.
Written in vernacular.
It's in vernacular, my lord. Your lordship will find that Grohita is Sheikh Wahidar Rahman, the plaintiff. Data, Sri Kailash Shaw, Sri Manoj Kumar Shaw. They were the defendant number 1 and 2. Now, my lord, kindly comes to page 44, internal page 3, how they became the owner. Second paragraph. অতঃপর উক্ত মাধবী বন্দ্যোপাধ্যায় দিগর তাদের অর্থের বিশেষ প্রয়োজন হওয়ায় মাধবী is not legal heir of পূর্ণেন্দু. Up to that is admitted. হওয়ায় উপরিক্ত
not.
My lord,
she is the widow.
Madhavi is the widow of Purnendu.
Yes.
Madhavi and their son and daughter, that is admitted.
Yes.
Up to that. অর্থের বিশেষ প্রয়োজন হওয়ায় উপরিউক্ত সম্পত্তি বিক্রয়ের ঘোষণা করিলে আমরা অর্থাৎ অত্র বায়নাপত্র দাতাগণ তাহাদের প্রস্তাবে সম্মত হইয়া তৎকালীন বাজারোচিত মূল্যে 20,000 টাকা পণে বিগত ইংরেজি 1987 সালে 3রা এপ্রিল তারিখে একটি এক ক্রেতা রেজিস্ট্রিকৃত সাপ বিক্রয় কবলা মূল্যে উপরিউক্ত সম্পত্তি যা বিশেষভাবে নিম্নতম না প্লেন ম্যাডাম এগ্রিমেন্ট ফর স্টে অ্যাপ্লিকেশন আছে এগ্রিমেন্ট ফর সেল আপনাদের হ্যাঁ আমাদের এগ্রিমেন্টই করছে আপনাদের এগ্রিমেন্ট তো স্টে না থাকলে করবে কি করে কপি দেন পরে মূলে যাহা বিশেষভাবে নিম্নতম শ্রেণীর বর্ণিত হইল তা খরিদ করিয়া উক্ত সম্পত্তিতে নিগ্রহ সত্ত্বে সত্যবান হইয়া মালিক রূপে ভাড়াটিয়া সহ ভোগ দখল করিতেছে। So this is how they became owner 80/70. This date is important because subsequent it was held to be void. Now on the next page, second paragraph. এক্ষণে আমাদের অর্থের বিশেষ প্রয়োজন হয় আমরা উক্ত সম্পত্তি বিক্রয়ের ঘোষণা করিলে আপনি অর্থাৎ অত্র বায়নাপত্র গ্রহীতা অত্র সম্পত্তি বাজারের সর্বোচ্চ মূল্য 75,000 টাকা মূল্যে ক্রয় করিবার প্রস্তাব করিলে আমরা আপনার প্রস্তাবে সম্মত হইয়া অদ্য তারিখে বায়না স্বরূপ নগদ অগ্রিম বাবদ 21,101 গ্রহণ করিয়া অত্র বায়নাপত্র সই সম্পাদন করিয়া দিয়া স্বীকার ও অঙ্গীকার করিতেছি যে অদ্য হইতে আগামী 2 বৎসরের মধ্যে অনুসন্ধানান্তে
আমাদের উক্ত সম্পত্তিতে যাবতীয় সম্পর্কে সম্পূর্ণ নিশ্চিন্ত হইলে ও উক্ত সম্পত্তি সংক্রান্ত যাবতীয় দায় দেনা মুক্ত হইলে আপনি পণের অন্দরে বকরি টাকা আমাদের প্রদান করিয়া আমাদের দ্বারা আপনাদের নাম বরাবর উক্ত সম্পত্তি সাব বিক্রয় বলে সম্পাদন করিয়া লইবে, তাহাতে আমাদের কোনো আপত্তি থাকিবে না। তোমরা দিস 2 বছরের মধ্যে ইজ ইম্পর্টেন্ট which is qualified by অনুসন্ধানে আমাদের উক্ত সম্পত্তি, and two things are to be done within these 2 years. The same thing is repeated
Yes.
page 46, internal page 5, second paragraph. আরো প্রকাশ থাকে যে অদ্য তারিখ হইতে 2 বছরের মধ্যে উক্ত সম্পত্তিতে আমাদের সত্য সম্পর্কে অনুসন্ধানে সম্পূর্ণ নিশ্চিত হওয়া সত্ত্বেও ও উক্ত সম্পত্তিতে আমাদের যাবতীয় দায় দেনা মুক্ত হওয়া সত্ত্বেও যদি আপনি পণের বকরি টাকা আমাদের প্রদান করিয়া উপরিউক্ত সম্পত্তি আমাদের দ্বারা সাব বিক্রয় বলা সম্পাদন করিতে ইচ্ছা প্রকাশ করেন এবং আমরা যদি তাহাতে কোনরূপ টাল বাহানা করি তবে আপনি আদালতে স্ট্র্যাটেজিক পারফরমেন্স অফ কন্ট্রাক্টের মোকদ্দমা দায়ের করিয়া আমাদের বিরুদ্ধে ডিক্রি হাসিল করিয়া আদালতের সাহায্যে উক্ত কবালা সম্পাদন করিয়া লইতে What is 50, my lord? This suit is 50.
Plenty is at page?
Page 50 of the stay application.
Sorry.
Lord, 94/2001, my lord. If your lordship, lord, may I just place the plane because I'll have to show the
Yes,
readiness and
please,
willingness
please.
also. Plaintiff begs to state as follows. Defendants are the joint owners of land measuring more or less 3 kata 8 chatak along with old 10 rooms, 3 rooms pakka, 7 rooms are partly tiles, partly tin shed. Most of the rooms are dilapidated condition situated at plot number so and so. Next paragraph. That by executing an agreement for sale dated 15/2/93 between plaintiff and the defendant in respect of the suit property, the defendant agreed to sell the suit property in favor of the plaintiff at a total consideration of rupees 75,000 only. And on the same date, plaintiff paid rupees 21,101 only out of the said consideration money as an earnest money. Earnest money. Defendant accepted the said earnest money of rupees 21,101 only, and the balance amount of 53,899 only will be paid at the time of execution of the deed of sale. The said agreement for sale dated 15/2/93 was executed by you in favor of your petitioner by a registered deed of agreement in the Kashipur year 1990s. Files a copy. Paragraph 3. That the defendants executed a power of attorney in favor of the plaintiff as their lawful attorney to execute and perform and to quit and vacate and or suit for ejectment against the tenants or any court cases relating to the scheduled property, and to represent in all the courts, civil, criminal or revenue or appellate in any registration office with the sign verify so and so written statement. That on the basis of the said general power of attorney, plaintiff filed 2 separate title suits, being title suit 416 of 1993 and title suit 22 of 97 on behalf of the defendants before the learned 4th Civil Judge Junior Division at CHOWDHURY against Nilangshu Banerjee and others, and Shamlal Agarwala for eviction from the suit property. Accordingly, Nilangshu is not son of Purnendu. Accordingly, under the said title suit were decreed ex parte on 3/7/97 and 17/9/98 accordingly, and thereafter the plaintiff requested the defendants to execute the deed of conveyance in favor of the plaintiffs by way of registration on receiving the balance consideration money of 53,899 only, but the defendants kept silent regarding the execution and registration of sale deed in favor of the plaintiff. But the defendant referred the matter that the plaintiff at all material times was and is ready and willing to perform his part of the contract and to pay the balance consideration money of 53,899 only, and got the sale deed executed and registered in the plaintiff's favor. That the plaintiff on several occasions uncounted requested the defendant to execute the deed of sale by way of registration before the appropriate authority on receiving the balance consideration money of 53,899 only. Defendants in every occasion deferred the matter, the reasons based on to the defendants. And thereafter, in the last part of November 2000, plaintiff further requested the defendant to execute the deed of conveyance in favor of the plaintiff by way of registration of receiving the balance consideration money of 53,899 only, but the defendant kept silent regarding execution and registration of the deed. The plaintiff day after day went to the defendant's house for fixing the date of registration and deed of conveyance, but all are in vain. The defendants have intentionally avoided to execute and also to register the deed of conveyance in favor of the plaintiff after accepting the balance consideration money. That the plaintiff is always ready and willing to purchase the suit property on payment of balance consideration money only, and willing to perform his part of the contract in respect of the said deed of agreement dated 15/2/93. That the defendant issued a notice dated 5/2/2001 through his advocate S.N. Dash by registered post with AD upon the defendants, requesting them to execute and register the deed of sale of the suit property in favor of the plaintiffs within 15 days from the date of receipt of notice dated 5/2/2001. The defendants received the said notice, copy of the notice, postal ID card filed herewith as part of the plaint. But the defendants did not comply with the said notice, that without prejudice to the plaintiffs, aforesaid claims for specific performance and other incidental claims for specific performance and other incidental reliefs, including injunction as paid for, the plaintiff claims in the alternative that if the learned court did not grant specific performance of agreement in his favor, then and in that event, plaintiff is entitled to return of the sum paid by the plaintiff, is entitled to return the sum paid to the defendant with statutory interest from the date of payment, the plaintiff to the defendant. So the defendants are trying to dispose the suit property by way of sale, mortgage, or lease, or tenancy to third party illegally. Plaintiff has been compelled to come before the learned court in clean hand with a prayer for permanent injunction, restraining defendants and their men and agents from selling or mortgage or lease or any kind of transfer of the suit property to the third party, except the plaintiff. Otherwise, the plaintiff will suffer irreparable loss and injury. Then cause of action of the suit arose on 15/2/93, date of agreement, and notice dated 5/2/2001. There is no other cause of action. In the meantime, these two dates, no further date is mentioned. This is the plaint. Now let kindly take section 16 of the Specific Relief Act.
Hey, two Specific Relief Act charge.
May I give my
fundamental. You have another copy?
Yes, I have.
Okay.
16C, my lord. There was the 18 amendment. Before that, proof. In 18 it is proof. Before that, it was who fails to aver and prove. This is not prior to 2018. But proof remains. This 13 book, Miller. This says who fails to aver and prove that he has performed. Even if even not, this is taken, the suit was disposed of prior to 18. So aver and prove, law aver and prove. So this
That is the amended provision.
Amended provision is only proof, but it says aver and explanation 2 also says there has to be specific averment. Explanation 2, Miller, must aver performance of for readiness. Only averment.
Only
is that on several occasions
by way of amendment, averment has given a go by.
Aver has been given a go by, but not explanation remains. So even also then also averment has to be there. Explanation 2. And proof remains. So they have to prove it by way of documentary evidence, because 93 to 2001 is not 8 years. For 8 years, only one letter in 2001. This will not be evident of their readiness and willingness. Mere statement will not.
Do you have the locus to raise this point? about the readiness and willingness of the parties to the agreement. You were challenging the very, what should I say?
The agreement that was.
I'm
No.
challenging the
Very-
title of
Very
the
title
proposed
of
seller.
the proposed
Proposed
vendor.
seller, yes.
Yes, vendor didn't have the title to transfer.
That is not my first
That is the principal.
principal point. On which
This
is that-
agreement will not, this
But a
submission will
limitation
not
point
hold
of-
good in this matter. The submissions forwarded by my learned friend will not hold good in this, but they are challenging the title. Not the performance of was not rightly done, we did not enforce, that is not the ground of challenge here. Whether
That
we
is-
had the title or not,
That
No,
is,
let them satisfy, they have not served,
Anyways.
they have not ensured service and water.
that I will.
Let them satisfy that. Without serving us, we could have filed a written statement. There is no proof of service on us.
Hmm.
So, my lord, this is not the other point regarding readiness. My lord, now, if your lordship, on the point of admission of second appeal,
Hmm.
we have used one application for additional evidence. If your lordship
Yes.
this stay application will also have filed that, it is there, page 64 is the terms of compromise, 94 is the decree.
64 is
Of
the
stay
terms of
application.
compromise.
Terms of compromise, and page 94 is the compromise decree.
Now, Nilangshu Banerjee is joining as party.
Nilangshu is joining, Nilangshu is not one of the sons. Everybody were parties except the plaintiffs here.
Hmm.
Shyamlal Agarwal, Hanuman Prasad Agarwal, they are not sons of Kanhaiya Lal, who was the original lessee. They filed the suit as plaintiffs. Pareshnath Shaw, Kailashnath Shaw, Manoj Kumar Shaw, they were not the defendants number 1 and 2 in the present suit. They were the main principal defendants. And Madhavi Banerjee, Nilangshu Banerjee, Shamali Mukherjee are the legal heirs of the original owner, Purnendu. So everybody was part.
Hmm.
Now, not kindly,
Why this chairman?
I don't know that chairman, but it was held that he is not an SIE party. In the terms, it was held that he is not an SIE party.
Hmm.
Now, may I place the terms of compromise from page 66 onwards. That the plaintiffs filed this instant suit for declaration of their right, title, and interest in respect of the suit property and injunction on the grounds as stated in the plaint. That the defendant numbers 1, 2, and 3 duly entered their appearance in this instant suit and intended to contest the same jointly as principal defendants. That the defendant numbers 4, 5, and 6, being pro forma defendants, also entered their appearance and intended to contest this suit. The pro forma defendant number 7 did not enter its appearance in spite of service of summons. As a matter of fact, pro forma defendant number 7 do not have any specific role to play, 7 except to note the record of rights of the parties herein relating to suit premises. Actual litigation is limited to the plaintiffs and defendant number 1 to 6. That your petitioners state that due to intervention of common friends and well-wishers, plaintiffs and the defendant number 1 to 6 have settled their disputes amicably out of court under the following terms and conditions. A. The parties herein do hereby admit that at a material point of time, Purnendu Banerjee, since deceased, being the predecessor of pro forma defendant number 4 to 6, was the sole and absolute owner of the suit premises, which is more fully and particularly described in the schedule of the plaint, as well as described in the schedule of the instant application. It is also admitted that after demise of said Purnendu Banerjee, pro forma defendant number 4 to 6 became owners of the suit premises by way of inheritance in accordance with the law of Hindu succession. It is also admitted by the parties that sometime during the middle part of the year 1987, pro forma defendant number 4 to 6, being in financial crisis, intended to raise funds by mortgaging the suit premises, and the defendant number 2 and 3 through defendant number 1 agreed to advance a loan of rupees 20,000 subject to execution of a ostensible deed of sale in their favor by defendant numbers 4 to 6 to avoid the provisions of Bengal Moneylenders Act. It is admitted by the defendant numbers 4 to 6 that the defendant numbers 2 and 3 paid a sum of rupees 20,000 to defendant numbers 4 to 6 through their father, defendant number 1, as loan, and simultaneously an ostensible Bengali Kobala dated 3/4/1987 was executed and registered by pro forma defendant number 4 to 6 in favor of defendant number 2 and 3. The said Kobala has been registered in book number 1, volume so and so, pages so and so, in the office of the Registrar of Assurance, Calcutta. the said Kobala was executed with a view to secure the repayment of the loan of rupees 20,000 as aforesaid. The defendant numbers 1, 2, and 3 and pro forma defendant numbers 4 to 6 do hereby admit that the transaction that took place by executing the Bengali Kobala dated 3/4/1987 was only for the purpose of raising loan by pro forma defendant number 4 to 6 for a temporary period with a view to secure the repayment of the said sum of rupees 20,000 with interest. The defendant numbers 1, 2, and 3 and pro forma defendant numbers 4 to 6 do hereby further admit that the transaction, that is the ostensible sale deed, executed by defendant number 4 to 6 in favor of defendant number 2 and 3 on 3/4/1987 was nothing but a loan transaction in its true intent and substance. The defendant numbers 2 and 3 admit that the pro forma defendant numbers 4 to 6 duly repaid the said loan of rupees 20,000 and the accrued interest to the defendant numbers 2 and 3 by installments, and defendant number 1, who is the father of the defendant number 2 and 3, confirms the same. It is also admitted that though the entire sum had been repaid by pro forma defendant number 4 to 6 to defendant number 2 and 3, neither any reconveyance has been made, nor the defendant number 2 and 3 returned the said Kobala dated 3/4/87 in favor of the pro forma defendant number 4 to 6, as there was a good understanding in between the parties concerned. It is submitted by the parties that since the loan amount was repaid by the pro forma defendant number 4 to 6, they, in exercise of their right of ownership, sold, transferred, and conveyed the suit property to the plaintiffs executing a deed of sale dated 30th day of July 2001, which is registered in book number 1, volume number 142, pages 265 to 272 for the year 2001 in the office of the sub-registrar at Damdam, who as tenants were in possession of the suit property. The defendant numbers 2 and 3 do hereby admit and declare that they never had any claim or right, title, and interest in respect of the suit property on the basis of Bengali Kobala dated 3/4/1987, 7 except the right of mortgage. The defendant number 2 and 3 further admit and declare that since pro forma defendant numbers 4 to 6 had repaid the entire loan amount of rupees 20,000 along with accrued interest by installments, they have no claim of any nature in respect of the suit property or against the defendant numbers 4 to 6 at present, and the defendant number 1 confirms the above. Be it noted here that while effecting this compromise, defendant numbers 2 and 3 duly returned back the said original Bengali Kobala dated 3/4/87 to pro forma defendant number 4 to 6. The defendant number 2 and 3 further admit that they never exercised any right, title, interest in respect of the suit property subsequent to the execution and registration of the said Bengali Kobala dated so and so to and the performer has been realizing rents from the plaintiffs who were occupying the suit premises as tenants at that material point of time and also thereafter for a long period. The defendant number 1, being the father of the defendant number 2 and 3, admits and confirms the same. Defendant number 1 to 3 admit that the plaintiffs have acquired right, title, and interest in respect of the suit property by virtue of a registered conveyance dated 30/7/2001, executed by pro forma defendant number 4 to 6 for valuable consideration mentioned therein, and the plaintiffs are the owners in possession of the suit property. That the parties herein have sorted out the misunderstanding in view of the facts as aforementioned, and defendant number 1 to 6 do hereby confirm the ownership and right, title, interest of the plaintiffs in respect of the suit property mentioned in the schedule below. So this was decreed, my lord. The decree is at page 94, my lord. Then the affidavits of the
Yes.
parties taken on record. Page 90,
Date of agreement is 15th of February 1993.
93.
And this declaration came on 12th of November 2003.
Yes, ma'am. This is not a compromise. The parties filed the respective affidavits also, and decree was passed. Then we have purchased 2001, the plaintiffs became the owner. We have purchased from the plaintiff subsequently. And we were added but not served, so we could not file our written statement to incorporate these documents. So on this point, I humbly submit that on the point on which the appeal is admitted, that holds good.
Just a minute. When was it admitted?
It was admitted on the
Yes.
3rd of January 2017.
Whether the learned courts below were justified in passing a decree for specific performance of contract in the plaintiff responded against him in the commission.
Very good. This is Milord background. Now, Milord, may I place Milord the relevant parts of the judgment Milord, because I'll not place the facts, only Milord the findings of the court, because the trial court has not bypassed the issue of limitation by holding that there is part performance 53A, since a portion of the property was handed over to them.
Why part performance?
Because not at the time of agreement, it says that 2 shop rooms are given possession of to them. So they have got possession of 2 shop rooms and there was payment of some money. So 53A. The 53A principle will not come Milord, in the way of the limitation. 53A Milord, they cannot be removed. If they're actually in possession, 53A, even in the absence of a registered conveyance, they cannot be evicted. But why 54?
Their possession is to be protected.
But why 54 will not apply, that is not clear. Anyway, Milord, should I not place some? I have not just two sets of judgments, 3 judgments, not only on the readiness, willingness, and Milord, and Milord, the parties should approach the court promptly. Delay in approach also, even if it is within limitation, but delay in approach shall be viewed strictly. Party should approach.
Well, we will come back to the decision at the
Later, after the judgment. Very short judgments, Milord. The trial court judgment starts from page 1. Plaint, I have already placed Milord, so I need not place the plaint case. The WS was filed by the defendants from page 2. The defendants filed written statement. May I place from here, Milord?
Yes.
The defendants filed written statement, not us, not the defendant 1 and 2.
Contesting defendant.
Contesting defendant. Denying the material allegations stated in the plaint, it was inter alia contended that the suit was not maintainable and the same is barred by limitation, and the plaintiff has no cause of action. Admitting the existence of agreement for sale, it was contended that as the suit was instituted 7 years thereafter, it is hopelessly barred by limitation. It was further stated that power of attorney was executed only for the purpose of looking after the suit property on behalf of the defendants. Defendants paid for dismissal of the suit with costs. Then the issues are framed, Milord. All total 8 issues were framed. Milord, the findings are from page 4.
Hmm.
2, 3, and 5 are taken up together. Point of limitation along with the cause of action and valid contract. Page 4 onwards. All these issues are taken up together as those are interrelated. It is also
who pleaded this 53A?
53A, Milord, I don't know. Agreement, it was there. Possibly it was argued Milord from the bar that the principle applies because the agreement was exhibited. And agreement says that the possession was handed over. So, but there was no pleading in the plaint. The execution of sale agreement was an admitted fact. Para 5 of the defendant's letter marked exhibit A and para 11 of the written statement. It is only argued that the suit is hopelessly barred by limitation. At the very beginning, the learned lawyer of the plaintiff also drew my attention to page numbers 4 and 5 of exhibit 1. Now it is a case of part performance as embodied in section 53A of the Transfer of Property Act. The equitable doctrine equate on that as done which ought to be done has been embodied in that section. Now the failure on the part of the prospective transferee to bring a suit for specific performance of contract within the period of limitation prescribed thereof under the Limitation Act does not lead to extension of the statutory right created under section 53A. So even there be any limitation to bring the suit within the scope and ambit of Article 54 of the Limitation Act, that cannot oust the plaintiff to seek his remedy under the doctrine of part performance. I do not understand what.
How it is relevant?
That apart, on a careful reading of Exhibit 1, it further transpires that there is a recital অদ্যহরিতে আগামী 2 বছরের মধ্যে অনুসন্ধানে আমাদের উক্ত সম্পত্তিতে যাবতীয় সম্পর্কে নিশ্চিন্ত হইলে ও উক্ত সম্পত্তি যাবতীয় দায় দেনা মুক্ত হইলে।
Yes.
Now Article 14 runs thus: specific performance of a contract period is 3 years and time begins the date fixed for performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. There are 2 dates. It appears that there are 2 clauses when the plaintiff becomes satisfied about the non-encumbrances in regard to the suit property, and another is when all the liability and duties of the defendant relating to the suit property will be discharged. The time for payment of balance earnest money will run. This is not erroneous finding. This is not the clause, because everything has to be done within 2 years. So the plaintiff is obviously not in a position to know when the liability and duties of the defendant will be completed, even if it is taken for the sake of argument that the 2 clauses are conjunctive in nature. The second part of column 3rd of Article 54 applies to cases in which plaintiff is not necessarily in a position to know of the occurrence of the contingency contemplated by the contract. Though it was cross-examined to PW1 about extension of agreement, but that question does not arise. There is a power of attorney, and by virtue of it, the plaintiff instituted civil suits which were decreed. The power of attorney goes to show that the plaintiff was empowered thereby to do all necessary acts relating to the estate of the defendants according to the Power of Attorney Act. And the act of the donee is the act of the donor. So there are good grounds to believe that till disposal of those cases, the liability of the defendant was not expired. I also consider the statement of DW1. According to agreement, after decree of eviction suit, I am to deliver the possession of at least tenanted rooms. So the plea does not stand at all. Apart from limitation, nothing was argued about validity of the contract. It was registered. The execution was admitted. It was not vitiated by fraud, misrepresentation, coercion, undue influence. Nothing shakes its validity. Actually, limitation destroys the remedy, but not right to claim. As soon as the defendant had pleaded limitation, he impliedly admitted the presence of cause of action because the plaintiff failed to institute the suit within 3 years from the time from which the period begins to run. That is accrual of cause of action. More so, the pleading goes to show the cause of action. In the result, all the 3 issues are decided in favor of the plaintiff. Here I pause for a moment, my lord. Taking the plea of limitation doesn't mean that I have admitted others. They have filed a suit for specific performance. So I can always take the plea of limitation. That doesn't mean that I'm admitting everything else. Then issue number 4 is, my lord, can the contract be specifically enforceable within section 10 of the Specific Relief Act? The issue starts from page 6, my lord. Twofold arguments are advanced, that as the defendant is ready and willing to return the consideration money already received, the relief of specific performance of contract should not be refused. But at this stage, I must say that the provision of section 10 of the Specific Relief Act is subject to provision laid down in section 23 of the Specific Relief Act. According to section 23, even if the contract, any sum is named as the amount to be paid in case of breach of the contract, the contract is yet to be specifically enforced if the court is satisfied that such sum is named for the purpose of specific performance of the contract. Here, though no such sum was mentioned, but nothing indicates the circumstances under which the contract cannot be specifically enforced. The second contention was that the defendant became incapable of performing his part of the contract, as he had no title in the land, because whatever title he had transferred to his erstwhile vendors. But on several occasions, DW1 admitted in his testimony that no registered deed, even no transfer deed was made by him. Consequently, in view of simultaneous effect of section 17 of the Registration Act and provisions of Transfer of Property Act, no title can be passed to anyone in absence of any registered transfer deed. In the result, I do not find anything to hold that the contract is not at all specifically enforceable. This is on the second question framed by this honorable court, madam. And if it is held to be inoperative by the court, competent court, then whether registered deed is required. This issue is decided in favor of the plaintiff.
All you need to do is to notify the registration authority that this deed has been declared as so and so inoperative.
Null and void.
That's it. That is to be taken note of. So that in future, if anyone wants to make any transfer based on that document, it will attract the attention of the registering authority.
Or the intending purchaser.
Yes.
The settled law is the issue number 6. Issue number 6 is, my lord, I'll just readiness and willingness. The settled law is that the averments in the plaint is to be read as a whole. It clearly indicates the readiness and willingness of the plaintiff to fulfill his part of the obligation under the contract. In this case, the plaintiff sufficiently pleaded about his readiness and willingness to perform his part of the contract. The plaintiff adduced sufficient evidence, both oral and documentary. The defendant also unable to controvert the testimony of the plaintiff. It is not proved that the plaintiff at any time suffered from any financial capacity to pay the consideration money. Hence, I do not find any ground to hold this issue against the plaintiff. I'm not coming to documentary evidence, my lord. I do not find what documentary evidence they have filed. To decrease has give evidence. Evidence about the I'll give you the evidence. No document was filed to show that any approach was made. Only oral. Page. I'll just hand over. কি document দিয়ে এখানে আছে না? ওয়াহিদুর রহমান। Last chapter.
No, Mr. Banerjee,
So this is the evidence.
your name is figuring as defendant number 11 in the decree.
Yes.
You were saying that page 12 of the paper book.
Raman Srivastava.
You are the appellant here.
I'm the appellant.
You were saying that no notice was served upon him.
No notice was served. I have shown you the order sheet.
Yes.
5 to 8 will not substituted service. 9, 10 refused. But 10 regarding 10 minutes, I couldn't find anything. If my lion friend can show that it is served, then this point goes. But
You did not appear
No, first appeal was preferred by my client.
by your client. No, in suit you didn't appear.
No. And no service at all. Court has to satisfy service. Without satisfaction of service, how can the court proceed? So this is the evidence. Kindly see what documents have been filed. I do not find any document. Court has held that plaintiff sufficiently pleaded about his readiness to perform. Plaintiff adduced sufficient evidence, both oral and documented. What is the documented evidence for readiness and willingness? I don't know.
Where is the cross examination part? This is the affidavits under order 18 rule 4. This is not complete document.
Chief threat. Cross. Number 10. Yes, sir. No, this is the word cross.
This is a cross examination.
But the difficulty is that I could not cross. The defendants who lost interest in the matter will not, since they had sold the property, they cross-examined.
Yes, even the yes. Virtually no document, at least deposition doesn't indicate admission of any document.
Only the agreement was filed and possibly some.
Even agreement was not admitted as exhibit.
Then issue number 1, page 8. Suit is filed within the statutory period of limitation. It has cause of action. Nothing either found either from the points of law or facts mixed with the law which caused the suit not maintainable. Hence, this issue is also answered assertive. 7 and 8. These two issues are taken up together for consideration as those are related to the release portion of the plaint. All the previous issues are answered in favor of the plaintiff. There is no reason as to why the suit will fail in regard to the release relating to specific performance of contract. The sale agreement is also found valid and binding upon the defendants. Plaintiff is also ready and willing to pay the balance consideration money of 53,000. So this is a fit case where the plaintiff is entitled to get the relief according to his prayer. This is not the trial court judge. Only the appeal court.
How your documents were admitted by the learned trial court? Try to find it out.
Milord, we need to check yesterday.
Yes, you just do it.
Milord, yesterday night at 8:30, Milord, I was briefed in this matter. Milord, I need to check up with the entire record as to what has happened. Because what I can find prima facie, what learned friend is saying, Milord, what I can find. Milord, page number 24 of the paper book is also incomplete. This document should have been put in the paper book as well. If he is relying on these documents, should have come to the
Second appeal, Milord, no documents are part of the paper book. First appeal, all documents go. Second appeal, খালি memo থাকবে আর পুরো করে judgment.
দেখতে হচ্ছে তো হাতে তো কিছু কাগজ নেই। কিছুই নেই কাগজ, ওটা ঢাল নেই তোরাল নেই নিতে শর্ট দেয়।
না ওটা বলো, তোমাকে পেপার জোগাড় করতে হবে।
The entire judgment was pronounced without taking into consideration any of the documents. Just check.
I have to check up.
Just check it. Yes. At least from the judgment, I don't find any.
Judgment, what documents are marked exhibit, there always there is a list of documents. These documents are tendered. There is no finding that what is missing in the judgment.
Well, I'll just say what I have understood from the submission of my learned brother, what he has stated before me and going through the papers, prima facie what I have understood, there are 4 sets of persons. I'll just try to explain it myself. There are 4 sets of person, my lord. Kindly come to this application under order 41 rule 27, my lord. Filed by my learned friend, can 6 or 23. No. This is a
Mr.
pretty
Bench,
old matter, my lord.
how much time will you need for that?
Lord, I'll place the appeal court judgment, these 2 judgments, and I'll try to find till now, Lord, any judgment on the second question of law frame.
Section
Lord,
70.
Second question of law is that section 70, effect of section 70.
No.
I'll look.
Suppose in a suit under Bengal Moneylenders Act, when the court declares the sale as
Inoperative.
inoperative,
Then that is binding.
naturally
On that, if I can find some judgment, I'll just place that. There must be some judgments. I'll place.
because while passing decree, we never direct go and execute a deed. That deed goes.
So 17 is of no avail. I'll just not submit on.
You are referring to page
Not page 10, it starts from page 10, the
10.
suit, I believe.
Yes.
This is a suit, my lord. There are 4 parties at loggerhead, my lord. 4 sets of parties. As I can find. My lord, kindly see in this title suit number 39 of 2002. Lord, for the why am I showing this? Lord, plaintiffs in this suit are the latest sellers of the appellant. They are the latest sellers. They are the sellers of the appellant. This is one set of persons. Second set of persons is 2 and 3, who are my sellers, intended sellers. 4, 5, and 6 are the sellers of 2 and 3. That is, he's the seller of the defendant number 2 and 3 here. And also the seller of 1 and 2. Also the seller of the plaintiffs number 1 and 2.
No.
They are also the sellers of
4, 5, 6.
4, 5, 6.
They are legal
They
heirs
acquired the property by way of
Inheritance.
inheritance. They transferred the property in favor of
2 and 3.
2 and 3.
Defendant number 2 and 3. Defendant number 2 and 3 is my seller.
Yes, 2 and 3 is your vendor.
Is my vendor. Lord, this 4, 5, and 6 is also the vendor of
your vendor. What do you mean by your vendor? You have
vendor, intended vendor.
Yes,
proposed. He's this 4, 5, and 6 is also the vendor of 1 and the plaintiff number 1 and 2.
Plaintiff number 1 and 2. Yes.
My lord, kindly see this.
Hence the suit.
Hence the suit. Hence the suit. I'll say what has happened. What is the mischief?
2 title deeds were running simultaneously.
Yes.
One executed in favor of your
My
proposed
client's vendors,
and other one
another is a sale deed.
Sale deed? No. Both the deeds are deed of sale.
No, my lord. My one is agreement for sale.
Your one, the persons with whom you entered into agreement, they acquired the property by sale.
By sale.
So long this decree was not there.
Yes. Suit was not even filed.
Yes. In the meantime, the vendors, having paid the money they borrowed, they sold the property to this plaintiff, Agarwal. Now, 2 title deeds are there. Naturally, question of title, section 34.
Yes.
Suit was filed,
Suit was filed.
ended up in a compromise, admitting thereby so and so.
That is what I'm afraid of.
Yes.
That is what I'm afraid of. I filed the suit. I filed the suit for specific performance.
When?
In the year of 2001.
2001.
Prior to this suit. 2000? March 2001. I filed my suit. Summons are served. Contest comes up. Their client may have what I have instructions. They were served, and the postal receipt and the track report is there on record. That is my instruction.
Yes,
for the
yes.
timing. For the
Just
timing.
find it
We'll raise that point later. I filed the suit for specific performance. My sellers, my intended sellers, and the different number 4, 5, and 6.
Sir, whatever you are indicating at, for that you need to take up a proceeding, seeking declaration that the compromise entered
Compromise is bad.
So you have to take out an plaint.
This
before
compromise is
competent-
bad. Why this compromise is bad?
It is to be declared by a competent court of law.
Yes. Look, what has happened? My agreement was there. I was enforcing it. my sellers and my seller's vendor, they went into a suit without informing me. I was not made a party in this suit. Well, then when one of the parties were entering into a compromise, they knew when in a compromise, there has to be a disclosure, full disclosure.
The point you are raising is to be adjudicated by a competent court.
That has to be.
Yes.
If we had the knowledge, this document comes up now. If we had the knowledge, we would have. The documents comes up now in a
Why?
4127. I was not made a party in that.
No,
How
no,
can I come?
in appeal also they
was
and
made
in
part of
suit
the
even.
stay.
If a
In the suit even there is
suit
a
was,
whisper.
they say that in the suit they were not there.
No, they were not there, but your vendor, what should I say, proposed vendors,
Yes.
they stated that. They
This was made
disclosed it
part of
back.
the stay application in 2016. So from
They didn't
16
place
they
any
are aware.
documents. Did not.
For last 7 years, they are
Lord,
aware.
what these documents have come in the first appeal.
No. You forget about the document. You come to the finding of learned trial court. There as DW1, perhaps if I am not wrong,
Page 24.
the court also observed that he has stated he sold the property either in the judgment or in the deposition.
The judgment.
Is it in page 24 of the paper book?
Page 7, my lord. 7 of the paper.
This point was urged. Second paragraph.
Incapable of performing his part of contract as he had no title in the land because whatever title he had transferred to his erstwhile vendors.
Lord, these documents did not come up. I don't know what he is stating. I need to check up the records. First, my lord, first and foremost, I
That
need to
you
check up
can
the
do.
records.
That you can do, but it was
What I know what to, I
It
don't know what
was
will I
where-
argue without the documents.
you were representing Wadia Rahman.
Yes.
I am
Plenty.
representing 11.
Wahidur Rahman.
Wahidur Rahman.
Plenty of 94.
Plenty of 94.
So it is well within his knowledge. In that suit only this fact was disclosed.
Cross-examined. DW was cross-examined that no valid
It's
registered.
not that they are bringing something new by way of additional evidence.
DW
It's already there.
I'll be very humble.
No, you just
one
go
day-
through the papers.
A little,
Take your time.
I'll take a little time.
Very well.
This record is lying in Barashad, I believe. Record ekhane nahi to.
No, record.
LCR went back to Barashad, I have to go up and check and take
Submitted
a.
all the papers. But they were in such a hurry. I sought for time for going through the paper, and my learned friends junior was so vociferous in.
No, he's not
He was-
a batchmate.
He was discharging his duty.
Yes,
Yes.
definitely.
And I need a copy of the stay application as well, kindly.
I'll give a copy. But not in DW Miller cross-examination also, I find that.
Yes, there is an admission.
They put this question, this point was put in defense, and it is not unregistered deed. There is no registered deed, so no title has passed to. And the deed was valid, 87 deed was valid. That was the cross-examination. So they were aware.
That was the stand taken by your counterpart over there.
I understand.
Since the registered document is there. So title is still with the with your vendors of your client, because there was no deed reconveying the title to these Banerjees.
What
But
I
that is
what
not
I
necessary.
find at the prime case, I need to go into the matter
No,
very deep.
you take your time.
I need to go. What I apprehend, what has been placed
Not a
before
very
me.
long time, let him get ready, because since the matter has been argued at long, there should not
No,
be
I
very
need a little
long
time.
gap.
At least
Next week,
record the काम करे fourth year को मोटा नहीं किया after my lord comes back.
I can't carry all these things in my little hard disk, There is every possibility to crash. You come back on 31st, 10 days time,
31st. 31st.
Yes.
31st of July. In the meantime, you do your research work on section 17.
Section 7.
Particularly, suppose in suits where validity of deed is challenged, what we do? We declare simply
Declare.
deed is not valid,
Not
it's
binding.
void and not binding upon the parties.
Then
We
no
never
registration.
direct go and execute another.
Reconveyance.
Never, just never.
So by the decree title will remain with you. Section 17, I don't think.
It shall not come into play.
I hope so. Again, let's do some research work.
Something.
Heard Mr. Banerjee, learned counsel for the appellant, and Mr.
D. Ganguly. Ganguly, Mr. Ganguly.
D.
D. Ganguly.
What D stands for?
Devnath Ganguly.
Devnath Ganguly. Mr. Devnath Ganguly, learned counsel for the respondent. Matter is adjourned to appear on 31st of July as part heard.
Obliged.
For one day, not he has read a lot. For one day, yesterday he was brief.
Yesterday night at 8:30, he came hurrying with the brief. Tomorrow we have to do this, man. And how will I do? I don't know. There's no documents on record.
Your friend was quite aggressive yesterday.
No, he's very aggressive. I fear.
Very aggressive, no?
No, that is good.
At any
The other side seeks adjournment, my lord. I don't know what happens.
He is
very aggressive. Oh, very, huh?
At 2 p.m. 31st.
2 p.m. 2 p.m. Thank you. It will copy now.
এবারে এই সৌরভ বাবু চলে গেছে আছে তো হ্যাঁ
আপনাদের কাছে
শিখা দিন ওটা রেখে দিন কোনো লয়ার হয়তো ফেলে গেছেন হ্যাঁ এখানে থাকুক কেউ এসে খোঁজ করলে দিয়ে দেবে Adito, call the next one. For order se আসুন তো দেখি ডাকুন পরে যে কটা আছে 10 মিনিট আছে কি আছে রিভিশন আছে বাকি সবটা তো হয়ে গেছে আমাকে ওই তিনটে দিন তাহলে yes do you have anything yes
application for step operation of the proceeding in the identical that matter my lord one of the measurement was can't say figure to
have you served
yes ma'am yes
huh? No, date fix going on. It is appearing upon mentioning.
yes ma'am
Then I am fixing a date. You just indicate the respondents, the date.
my lord kindly sit down same subject matter same land plot so land only purchases 2 persons for which my lord 2 cases 2 suits were filed.
Who is Orunmoy Bishwas?
Orunmoy Bishwas is the my lord purchaser.
Purchaser.
Yes, my lord.
So we need to hear him also.
Actually, my lord, the party same advocate is appearing.
Very well. You just give him a notice indicating that matter will be taken up. Say today is 20th. It will be taken up on 27th.
My lord.
You just give a notice and come back on 27th. I will dispose of the matter. What's your good name? 67. Your good name, sir?
Devobroto.
Devobroto
Koron.
Koron. It is printed as Devo Priyo Koron.
Oh, that would be my son.
Your son?
Yes, my younger son.
Mr. Koron, learned counsel for the appellant, is present before the court. Respondent is not represented. let the matter be listed on 26th of July. The appellant is to notify the respondent indicating the date of hearing. ওই তিনটে ম্যাটার যেটা আছে না আজ থেকে কি শুরু হয়ে গেছে কাজ হবে না দিদি ঠিকাদি কোথায় ছোট্ট একটা অর্ডার আইটেম নাম্বার এটা হচ্ছে কত 16 না 15 কি হবে 14 15 16 by a common order I propose to dispose of CO 2336 2337 2336 of 2012 2337 of 2012 and 2338 of 2012 এই রঞ্জিত কোথায় আমার ফোনটা নিয়ে শোনা the petitioners expressing their displeasure over the judgment and order dated 31st of May 2012 passed in Miss Appeal number 348 of 2009 by learned additional district judge 9th court at Alipur has preferred this appeal preferred this application under consideration. Briefly stated, ওই এইটা হ্যাঁ এটা না ওটাই মনে নেই এটা দেখছি থাক এটা ওর বাজে এমন ভাবে হ্যাঁ এইটা ঠিক এটাই আছে partition একটা এনেছেন না briefly stated, the suit property briefly stated in a suit for partition filed by
My lord, I beg to be apologized to my lord. I beg pardon, my lord.
Yes.
Disturb your lordship. But actually on 26, I have some difficulty, my clerk has said, on 27.
okay 27 this is what 27 করে
Much obliged, I'm grateful.
Sudhir, okay, no, sorry, briefly stated, Sudhir Haldar, no, Sudhir Haldar filed a suit for partition before the learned second Munsif Baruipur in title suit number 203 of 1979. The suit was preliminary, the suit was decreed in the preliminary form thereafter. One of the co-owners, Santosh Haldar, died intestate on 16th of September 1988. No, sorry, died intestate, leaving behind him surviving his wife, surviving his widow, son and daughter. Who widow, son and daughter who sold and transferred their share in favor of Kalidas Pal. Aruna Mondal, the legal heirs of Bolai Haldar, one of the co-owners, sold and transferred her share on 13th of March 2001 in favor of Reva Pal. The transferees, as aforesaid, got impleaded in the suit for partition, impleaded, I-M-P-L-E-D, impleaded in the suit for partition and plaintiff Sudhir Haldar and the plaintiff of the said suit for partition filed an application under section 4 of the Partition Act in exercise of his right of preemption. Or in other words, his right to buy off the share of the stranger purchaser. Stop. The said petition was registered as Miss Case number 121 of 1998. Stop. Learned Trial Court, however, was pleased to reject the said application stop aggrieved by the order of learned trial court. Sudhir Haldar preferred an appeal against such order. Stop. It was registered as misappeal number 348 of 2009. Learned Appellate Court was pleased to dismiss the appeal on the ground that Section 4 of the Partition Act 1893 can be placed into service only in the event the stranger purchaser of share in the dwelling house 6 partition. Stop. In the present case, the stranger purchaser did not approach the court for partition. He purchased the share of one of the co-owners. They purchased the share of the co-owners. No, one, the co-owners by 2 different deeds. Therefore, according to learned appellate court, lower appellate court, the order passed by learned trial court was absolutely correct, and refusing to interfere with the said order, the miscellaneous appeal was dismissed. Stop. Hence, this petition under Article 227 challenging the order of lower appellate court. Para. Mr. Aturup Banerjee, learned counsel on behalf of the petitioner, strenuously argued that share of the dwelling house since has been transferred to a stranger during pendency of a suit for partition, when the stranger purchaser entered into appearance under Order 22, Rule 10 of the Code of Civil Procedure, Code, he has assumed the status of one of the plaintiffs for the simple reason that in a suit for partition, parties to the suit are considered to be plaintiffs. Stop. Therefore, the statutory provision as laid down under Section 4 needs to be interpreted in in a manner as if the suit was filed, as if the um, stranger purchasers approached the court for partition along with other co-sharers stuff in order to maintain the sanctity of the family dwelling house. Learned sanctity of the dwelling house, the stranger purchaser should not be allowed to intrude. Stop. This basic principle behind the legislation was overlooked or not considered by learned courts below. Refuting such contention, Mr. Gopal Ghosh, learned counsel, contention, Mr. Gopal Ghosh, learned counsel for the opposite party, submits that the Honorable Apex Court, in the case of Gautam Pal, in the case of Gautam Pal and so to can বলে দিন ডাউনলোড হোক ততক্ষণ আমি নামটা বলে দিচ্ছি made it clear that section 24 section 4 of the Partition Act can only be placed into service if the stranger purchaser approaches the court for partition and not otherwise. There is no room to interpret section 4 of the Partition Act in any manner whatsoever. Stop. I perused the তার আগে একটু লিখে দিন while my attention is drawn to the order dated 26th of September 2012 passed by Honorable Coordinate Bench, where direction was given to prepare a paper book from the paper book. I find that there was a paper book. I find that the opposite parties purchased one or more people live, semicolon, a residence or abode. Stop. When a building is used as shop, when part of the building is used as shop and godown, it loses the character of a dwelling house per se. Per se. Stop. Para, upon plain reading, or continue করতে পারেন, upon plain reading of section 4 of the Partition Act, it appears that where a share of dwelling house, where a share of dwelling house belonging to an undivided family is but has been transferred to a person who is not a member of such family and such transferee sues for partition, comma, the court shall, comma, if any member of the family being a shareholder shall undertake to buy the share of such transferee, comma, make a valuation of such share, and direct the sale of such share to the shareholder. Stop. It goes without saying, when a statute says a particular thing is to be done in a particular manner, it should be done in that manner and not otherwise. Stop. As I have already pointed out, the property purchased is not a dwelling house, and the stranger purchaser did not initiate any suit for partition. Stop. However, if any proceeding is taken out for execution of final degree by the stranger purchaser, দরকার নেই, ওটা বলার দরকার নেই। The order impugned, in my opinion, does not warrant any interference, and interference stop করে দিন। The revisional application is bereft of merit and is dismissed, however, without cost. তারপরে যা সেন্ড ডাউন হবে হবে। এই আদিত্য, তিনটে সিও একটাই পিটিশন আছে, তিনটে আলাদা আলাদা হবে তো? একটু অর্ডার নাম্বারটা বলুন তো, বা অ্যাপিলের নাম্বারটা ওইটুকু এক আছে কিনা, তারপরে দেখা গেল ওই নাম্বার গুলো ভুল আছে। একটা হচ্ছে মিস অ্যাপিল 348, হ্যাঁ অ্যাপিলের নাম্বার, হ্যাঁ হ্যাঁ মিস অ্যাপিল নাম্বার 349। ও আর একটা দিন সুধীর হালদার, রেবা পাল, 300। তাহলে অর্ডারে, হ্যাঁ, এইটা হচ্ছে রাজেন্দ্র প্রসাদ ঘোষ, অনেক লোককে বিক্রি করেছে। যাক, মিস আপিল হবে খালি 3টে না, আপনি একটাই অর্ডার করবেন, কি করবেন আলাদা আলাদা, এটা তো কপি পেস্ট করেই করবেন আপনি, 3টে আলাদা নাম্বার, 349, 354 আর 2009। না, 3টে তো ঠিক। রঞ্জিত কোথায়?